1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Bond issue?
You're correct.
No, I want to change my outfit.
So are we otherwise ready? Would you ask Mr. Anderson to come in, please?
Yeah, we are.
Call the jury?
Yes.
And can you bring in some
Yes.
milk? Thank you.
Hello?
Would you come down, please?
Yes.
Thank you. Good morning, everyone. Happy St. Patrick's Day. And let's continue with the state's presentation.
So I should start with the redirect, Your Honor.
You may guest.
Yeah, thank you. Yep. Detective Correa, you were asked some questions by the defense about whether there were periods of times where any calls were missed, specifically by the defendant, specifically using the A&S phones. In other words, calls he did not answer. Do you recall that line of questioning?
Yes.
And do you recall that during the testimony in this case, the state's focus has been on a specific time period, which was May 17th in the evening hours from around 7:34 p.m. to about 11:19 p.m. Do you remember that time period is a period that we have focused on?
Correct.
And so as to that time period on May 17th, are you able to indicate, based on your review of all the materials, is that a time period where the defendant, just as the defense mentioned in the time periods they asked about, where there were no phone calls answered on that A&S phone? Is that also a time period where that was true?
Yes.
But did you further review to see if any calls during that same time period, around 7:34 p.m. to 11:19 p.m., did you find that there were also no calls that were either made or answered on the Moto G6 phone during that period of time?
That's correct.
And did you also find during the time period we're speaking about that not only were no phone calls responded to on the ANS phone, but no phone calls were made on that phone as well during that time period?
Correct.
And then I'm going to ask you about texts. So as to any of the devices that you are aware of that the defendant possessed, were there any texts that the defendant answered or that his devices answered, or were there any texts sent out on those devices during that time period of 7:34 p.m. around to 11:19 p.m.?
There were not.
Now, were some texts received that were not answered during that time period?
On the ANS phone, yes.
Okay. And then finally, were some of the electronic devices, or at least one of the electronic devices the defendant had, ones that could be utilized for internet searches?
Yes.
And as to the devices we've talked about, was there any evidence of any internet searches done by the defendant, again on May 17th from 7:34 p.m. to 11:19 p.m.?
No.
Okay. So I'm going to ask those same kind of questions about not just the ANS phone and whether it missed calls, but about all those other ways that a person can show that they are aware, awake, involved, right? So I'm going to ask about all of those kind of devices as to in response to what the defense asked you. So do you recall the defense asking you on May 5th from a time period that I think ended up being around 11:15 a.m. to 3:30 p.m.? Do you remember that being brought up by the defense?
Yes.
Okay. And your testimony was, based on the exhibit you saw, that it did not appear that any ANS phone calls were answered during that period of time. Is that accurate about what you testified to previously?
Well, I believe there was the...
I'm saying
it
just...
began and
Yeah.
ended with calls, and then in between there were none, correct?
Okay. And so that time period covered was 11:15 a.m. to 3:30 p.m. around, right?
I believe so, yes.
Okay. So I'm now going to show you what's been marked as State's Exhibit 350, and this is regarding the Moto G6 phone. Can you set up the machine for me and put it up there? Show you first, I'll start with the first page of State's Exhibit 350. Again, does this appear to be phone records regarding the Moto G6 phone, essentially the secondary phone of the defendant, covering the time period of that 11:15 a.m. to 3:30 p.m.?
Yes.
And during that 11:15 a.m. to 3:30 p.m., were any calls made on this Moto G6 phone of the defendant's? Did that phone make any calls out?
Yes.
And when did that occur?
That was May 5th of 2020 at 12:08:45 p.m.
Okay. And then were any texts made from this phone during that time period?
There was.
Okay, and that again was on this same phone, the Moto G6?
Yes.
And so when did this phone text out during that time period that counsel was referring to?
12:17:22 p.m.
And then is there further a web history, meaning this phone was used to access the web during that same time period, between 11:15 a.m. and 3:30 p.m.?
Yes, there's a web history beginning at 12:25:34.
Okay, so if you review that page and then on to page 2, can you tell when that web history ends, as best you can tell from this exhibit?
Based on this exhibit at 12:34:13 seconds p.m.
So that's, if we don't just ask about the ANS phone, if we ask about other devices, all of that was activity during that same time period. Is that correct?
Yes.
Okay. So let me, I think that you were also asked about a different time period, a May 10th time period. Do you recall being asked whether you saw any activity on specifically the ANS phone on May 10th from, I think it was around 3:48 a.m. to 1:30 p.m.? Do you remember that time period being a time period you were asked to consider about whether phone calls had been answered?
I recall the times in the day. I don't recall the exact times, but I do recall being asked about that, yes.
And did you, but you weren't asked about whether, other than calls, whether there was any communication on any device. Is that right?
Correct.
Okay. So again, as to that ANS phone, did that phone also have the capacity to text out, at least on occasion?
The ANS phone?
Yep.
Yes.
So I'm going to show you now what's been, well, I'll just ask, did the ANS phone, I'll show. So I'm going to show you what's been marked as State's Exhibit 349. Ask you if that appears to be a text on the ANS phone during that time period that you were asked about. Does that appear to be a text that went out on that phone?
Yes, there's a text message on 5/10 of 2020 at 9:09 and 45 seconds a.m.
Okay. Thank you. You were asked a question about a tip that had come in regarding a person in the proximity of Rosalio Gutierrez's patio on May 18th. Do you recall that?
Yes.
And what were any considerations you had about whether that should be followed up or whether it could be followed up?
There was no information to follow up with the person who had called on it. So we had really no direction as to who to follow up on. There are no video cameras located in that area of the apartments, or actually in the apartments at all. So there was nothing for us to follow up on that end either.
Based on the existence of a number of cigarette butts, was Rosalio Gutierrez's patio in close proximity to an area where a lot of cigarettes were being smoked outdoors?
Yes, directly adjacent to his patio.
And was it heavily raining on May 18th?
That whole period of time it was raining, I can't say specifically during the middle of the day that it was raining heavily, but throughout those 3 days it had rained heavily, yes.
And did Rosalio Gutierrez's porch area have some sort of a sheltering?
I don't object to relevance. That's where this line of questioning is going.
Was there some sheltering over the patio area of Rosalio Gutierrez that would be within a few short steps of where people were smoking?
So above his patio would have been the deck area of the upper apartment, of the upper unit.
And how many steps would you estimate that was from where the smoking location appeared to be?
Oh, his patio is directly adjacent to where the grass area is.
You were asked about an area. I don't know if we ended up deciding whether it was 1 or 3 blocks, but a area that has a few trees or some trees that's in close proximity to Wood Creek. Do you recall that question?
Yes.
During all the time since Rosalio Gutierrez's bloody apartment was found, has there been any bodies or body parts that have turned up in that location?
No.
And you were asked some questions about the searches at the different locations, in this case, including a tree farm described by the defense as the Anderson tree farm. Were there work boots in any way associated with the grandfather that were found at that location?
No.
And also not at the lake house, the Belgium lake house from Miss Brown Williamson?
They were not.
And then what about at the defendant's home? Were there a separate and distinct pair of work boots that would have been grandfather related?
There was one pair of work boots that was located.
And you were asked some questions about the missing persons database nationally, and the ways that that would be reflected officially, right? That you've kept that open. Is that correct?
Correct.
And if the police department has referred this as a homicide, made a decision this is a homicide, why would you keep that kind of database open? What would be your purpose in doing that?
The main purpose is that without a database, there would be no way to determine if remains were located, to compare those remains through DNA or through whatever means to confirm that they may be related to, in this case, Mr. Gutierrez. So keeping that open, even though the case is going and has been referred, it gives the ability that at any point, at any time, if remains are located and there is a comparison made, that, well, Kenosha Police Department as well as the family involved would be notified of that. So without that database, we wouldn't have that ability.
Judge, I have no further questions. Thank you.
Cross-examine.
Nothing, Judge.
You may step down.
Your Honor, the state has no further witnesses in its case in chief. We have to move in a couple of additional exhibits. So just in terms of the testimony just now, I'd move admission of State's Exhibit 349 and 350. And do we have any other outstanding exhibits, counsel?
I don't believe so.
So we would just ask the court to reserve the right to move in additional exhibits, Judge, if in this massive amount of exhibits, and now with a second clerk, just to make sure that we have the ability to reserve that right if that becomes necessary in the future. But if the court allows us that privilege, then the state at this point rests.
All right. Any objection to the exhibits which are offered?
No objection to the exhibits. The defense, prior to making argument, also has several exhibits we'd like to move in. That would be Defense Exhibit 335, 336, 337, and then these were photos. It's going to be defense exhibits, and Madam Clerk, if I have multiple numbers, would you just like me to say like 57 through 60? Okay. Defense exhibits 57 through 60, 62 through 72, 74 to 76, 106 to 108, 127 to 129, 131, 133 through 136, 140 through 141, 143 and 144, 145 through 162, 177, 227, 229, and then I had noted when I received an exhibit list that defense exhibits 248, 250, 252, and 253 had not been marked as received. However, those were the documents that Attorney Birdsall had used on his cross-examination of Marquand Washington, and he had moved them in and they were accepted. So I just want the record to reflect that those had been previously received. I also have notes that Exhibit 262 and 319 were supposed to be received as well, but those were not marked. So I'd be asking that those markings be made and then the exhibits I had mentioned be admitted.
You said some of them had not been numbered?
No, they had been numbered. So defense exhibits 252, 253, 250, and 248, those had been already received.
Right, that I heard.
But it wasn't marked. Like
It wasn't marked that they had been received?
Correct.
Okay, I thought you meant they hadn't been numbered.
Sorry for the confusion.
Okay, not a problem. Any objection to receipt of the foregoing?
So, counsel, are any of those the items that were marked but objected to, so
No.
they're not admitted?
No.
Because I noticed that a couple of those were, I think there were 2 times that you approached witnesses. We did not have the exhibits go in, but I think you maintain them, I assume, for purposes of making sure the court had them. Were you moving those into evidence as well, or not those?
No, not those.
Okay, all right. So upon the assurances of the defense that the 2 exhibits I recall that were not allowed to be presented, Judge, were not. Yep, that's what I meant. Upon their representations that those are not included in their list, I have no objection.
All right, received.
And then Attorney Aubert will be making argument.
Reserve. You may reserve. Till a later point in the morning. Pardon me?
We have a motion outside the presence of the jury.
The
At the
typical
conclusion of the state's case.
post-resting motion?
Yes.
It can rest for a while.
Okay.
But it's reserved. Do you wish to present a defense?
Yes, Judge.
You may proceed.
Thank you. The defense will call its first witness, Julianne Avila.
Do you solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Good morning. Could you please state and spell your name for the record? Oh, do you want to check see if the mic's on?
Is the green bar up?
There you go.
That's much more appropriate for the day.
My name is Julianne Avila, Julianne Avila.
And how are you currently employed?
I'm a crime scene response specialist with the Wisconsin State Crime Lab out of Milwaukee.
And can you explain to the jury what that occupation entails?
So we respond to homicides, other investigations for maybe smaller departments that need help, officer-involved shootings, or any other major event that a submitter or an agency in Wisconsin may need help with.
And what kind of qualifications do you need for your job?
There are 4 of us who are full-time in crime scene response, and then we have a program chief. So for the crime lab, what we did was we have forensic scientists who had a major discipline, some of us DNA, firearms, latent prints. And then what we do is we go through training to learn how to approach a crime scene, how to respond, how to go through it, how to look for evidence that may be appropriate for the scene that we're called to, how to do proper collection techniques, documentation with photographs and video, and then eventually write a report. And so we bring our bench knowledge to the scene as forensic scientists to kind of try to get the best evidence that we can.
And how long have you been working as a crime scene response specialist?
So I've been a crime scene response specialist since January of 2020, but I've been involved with the crime scene response team since 2015.
And prior to 2015, were you still working in the field?
Yes.
And what type of education background do you have that assists you in your position?
So my degrees are in criminal justice and a minor in biology, and I have a master's degree in forensic science. And then we had our other specialized training within the laboratory to become crime scene response specialists with the training director at the laboratory.
And so you had noted that you had been working in crime scene response since 2015. Was that with the Wisconsin State Crime Lab, or was that elsewhere?
That was with the Wisconsin State Crime Lab.
So since 2015, you've been employed with the Wisconsin State Crime Lab.
I've actually been with the crime lab since 2002. I was a latent print and footwear examiner.
So just focusing on your work as a crime scene response analyst, do you have to prepare reports for the things you do? Is that a normal duty in your job?
Yes, it is.
And can you explain that for the jury?
So the reports we generate explain who called us, who responded to the scene, what their duties were at the scene, what we did, what we eventually collected that may have been of importance. And then we also, before we leave a scene, we give over all the evidence that we've collected. So we may also make mention of what was given to the officers at the scene. And then we tell them, that how many photos have been taken, where they can get those, and just kind of the overall documentation of what we did at the scene.
And during your time span of employment, approximately how many of these reports have you written?
Oh, I'd say probably maybe 75 to 100.
And I want to direct your attention to 2020. Do you remember doing work on a case regarding Zachariah Anderson?
Yes.
I'm going to show you what's previously marked as State's Exhibit 43. Judge, may I approach the witness?
Go ahead.
Is that a report that you prepared in this case?
Yes.
And how do you know that it's a report you prepared for this specific case?
It has my name and my signature on it. I see Lisa Treffinger's initials on it, as she was the peer reviewer of this case, with our laboratory case number on it and our seal on it.
And the case number correlates to maybe perhaps any and all work that the crime lab had done as it relates to the investigation.
Yes.
And what is that case number?
R20-1497.
And looking through the report and the date on that is September 3rd, 2020?
Correct.
Looking through the report, is it a accurate depiction of the report you prepared without any modifications?
Yes, it appears it is.
Judge, I'd like to admit State's Exhibit 43 and publish to jury.
Is there objection?
To publishing the report?
Just
hand
gonna,
it to them?
no, I'm just going to put it on the thing.
Sure.
Go ahead.
Okay, so while this is up, if you could explain to the jury what this report is about.
So we received a Dodge Caravan into the laboratory that I was to look for any kind of possible blood evidence in the van. So I'm just explaining that both myself and Lisa Treffinger actually looked at the van. I took the photographs of the van. And then I talk about some testing that I did on stains that I observed in the van and the condition of the van, and eventually what it was that I collected out of the van.
Okay, and so item A is the van.
Correct.
Reviewing the van, processing the van, you created a little chart.
I did.
Okay, and can you, what does this chart depict generally?
For the record, can we just say what the
Sure, sorry.
exhibit is?
Defense Exhibit 351.
I created this chart just for my own personal notes, just to see where I tested stains in the van. I did not collect these stains, but I just wanted to make note of where I had done some testing. I noted where there was carpet missing from the van, and that's generally what this is, just for my notes.
And so wherever, let's start with the steering wheel. You had made a note for the steering wheel. What did that note indicate, if you remember?
There was a stain, a darker stain on the steering wheel that I observed, and that was just something that I tested.
And then if maybe you could just walk through each of the items that you noted and what you did.
Sure. So they don't have specific, some of them have numbers of kind of just what areas I tested. What I did was I used something called phenolphthalein, which is a presumptive test for blood. It's not a determining factor. It just is. It could possibly be. And so I tested the steering wheel. I tested the running board along the side of the driver's side of the vehicle. There was an area behind the front passenger seat, the seat belt, the carpet, and then the seats were all missing out of the van. So I tested a few areas of the carpet. I also tested it, if you know, like sometimes in the back of those vans they have like cup holders where the seats would be. There were some reddish stains there that I tested. I tested areas on the metal parts, which is the bottom part that had no carpet. I tested along there with phenolphthalein, and they were all negative.
And when you say they were all negative, what does that mean?
There was no indication of blood using phenolphthalein as the presumptive test.
Did you do any other tests strike that. There are other types of tests that can be employed to determine the presence of, are there any tests that can be employed to determine the presence of blood?
Yes, so usually when we start out looking for blood, we're using basically just a high-intensity flashlight, looking for any signs that appear to be reddish-brown stains, as blood usually appears to look. After that, something that you can't see with your eye, we might employ luminol, which you may have seen on TV. If you spray it in the dark, instead of giving a color change, it gives a change of light. It emits like a light. So once I was done testing with phenolphthalein, I used luminol and sprayed the van with that, and I saw one area that had a little bit of a glow, and I collected that stain.
And that stain, though, wasn't further tested?
I believe it was tested, but that would have been by the DNA unit. I didn't test it with any kind of presumptive test.
Was that A2?
Yes,
Okay. That wasn't A1?
correct.
And can you explain to the jury if luminol reacts to any other substances or things other than blood?
It does. It's just a presumptive test, like phenolphthalein. It'll react to rust, bleach, and some other kind of cleaning products.
So it does react to bleach?
It can react to bleach, yes.
You had noted that there were some bleach stains in the vehicle, or did you?
I did. They appeared to have the consistency of what bleach might look like.
When you did the luminol testing, did it react to those areas?
No.
And then you had noted that another thing that luminol can react to is rust. Did you observe any areas of rust in and around the vehicle?
Yes, the car did have rust.
What was your overall impression of the state of the vehicle?
The vehicle was had a significant amount of wear and tear to it. As I said, the carpet was missing. The carpet was dirty. There was a lot of clutter in it.
And was it very dirty in the inside?
It was.
You had also taken some pictures.
Yes.
I'm going to go through them. It's a packet of pictures that were taken, marked as Defense Exhibit 352. Show you the first picture in that packet. It looks like a big dark screen, but can you explain perhaps what this photo was?
I don't remember what that.
Do you take photos when you're doing the luminol processing?
I do. And usually, usually what we do is luminol, because has to be taken in the dark. Sometimes your exposures will be a little too dark, and it's hard for that luminol to show up. It has to be like sometimes maybe a minute or a minute and a half exposure to try to capture it. And because the luminol was so faint, it doesn't really show up very well on this photograph.
Okay. The next picture.
I believe that is the area behind the driver's seat in the back. So in the back area where there would possibly be bench seats, there were some compartments back there and cup holders. Okay. These are just the items that were inside.
And was this we can see a reddish stain in this photo?
Yep.
Was that one of the stains that you tested?
I don't know for sure. I had marked them with like Post-it notes and stuff, so I'm not sure if that was one of the ones I tested or not.
Okay, I'm going to skip forward and then we'll go back to this photo. I might have to hand it to you just because of how
Yeah.
I can make it brighter.
Okay.
It's terrible.
Yep.
Okay, so now looking back at this previous photo,
Yes.
does that help?
Yes.
Okay, so that was an area that was tested
Yes, it was.
and what came back negative?
Correct.
And why did you want to test these stains?
Well, because of the color, of the appearance of them being a reddish brown stain, I was testing whatever I saw that could possibly be blood.
This photo area.
So this is a mid-range photo of the footwell of the driver compartment.
And did you observe anything of interest in that area?
No.
And did that area appear to have been cleaned?
Cleaned? No. So this is the step area going into the cargo area or the passenger area behind the driver's seat.
Okay, and so this is the step threshold area that you tested?
Yes.
Okay. And I'm going to show you another picture of that. Is this just a close-up?
Yes.
And why did you test that area?
Again, there was a reddish stain there that I was interested in.
Because it possibly could have been
Blood.
blood?
Yes.
And what was the result of that specific test?
It was negative.
Can you describe what this is?
This is the back area, the very back area of the van by the lift, back tailgate of the van. This is the metal part. You can kind of see a little bit of the carpet in the upper right-hand corner. And so this was just the bare metal.
And the bare metal, was there a lot of dirt and debris on top of it?
It was dusty. It was kind of dirty.
It was dusty?
Yeah.
Okay. And there's also arrows in this photo?
Yes.
And are those arrows depicting areas that you tested in that area?
Yes.
And the test for presence of blood?
Yes.
And what were the results of those tests?
They were all negative.
Okay. What is this, besides the obvious?
The steering wheel in the van, I have an arrow pointing to what looked like a reddish brown stain on the wheel.
And again, why did you want to test that stain?
Because of the appearance, I wanted to test it with phenolphthalein,
And the appearance of it?
being like a reddish brown stain,
Okay. And the result of that test?
was negative.
Do you remember this?
I do.
This is the stain on plastic. This is the stain.
I believe this is the stain on the headliner above the cargo door area. It would have been on the driver's side. So as you lift the door, it would have been right up here at the top.
Okay. And that was tested?
It was.
And that was negative?
Yes.
There's this picture. Is there a reason you took this?
Just documenting the overall condition of the van and what was inside.
Okay. So in this case, the clutter.
Yes.
In this picture, was there any significance or just another overall?
Again, just documenting the overall condition of the van.
Okay, and in this picture, I'm going to point to it on here, we see this container. Were you able to determine what that container was?
I don't remember offhand what that is.
Do you remember finding any sort of cleaning wipes or any wipes in the van?
I think there were, and that could be it. There were bleach wipes, perhaps.
Judge, I'd like to move into evidence defense exhibit 352.
Is there objection?
No objection.
Received.
And I have no further questions for this witness.
Okay, so we talked, I think, about A2, Ms. Avila. We haven't talked about sample A1, have we?
No.
Okay, so I'm going to show you what's been marked as State's Exhibit.
State's exhibit 1, 313.
So again, this is State's Exhibit 1, 313. It's going to show up on the screen up there on the television. Is that a picture that you took from back in the time of this van review?
Yes.
Do you recall what day you and Ms. Treffinger did this process with the van? It appears to be prior to June, or prior to late June at least. Do you remember when this was?
I don't remember the specific date, but I believe it was in May.
So if I indicated to you the photograph is dated 5/21, is that an excellent way to figure out when you did this?
Yes.
And so if you look up at the exhibit, does it have a time and date of the photograph? Yeah. So are these the photographs? Is your photography in this, if it says it started on 5/21, does that refresh your memory about when this happened?
Yes.
Okay, so just for purposes then of the record, when do you believe, based on your memory being refreshed, that these photographs and this testing is completed or done?
I took these photographs on 5/21, it appears.
Okay, of 2020?
Yes.
So you were asked briefly about the condition of the back of the van. Does this accurately reflect what you saw on May 21st?
Yes.
So when you saw it, the items that would normally anchor in the carpet or be anchored in by the carpet were situated off as they are in this, or have you manipulated that in some way at this point?
I pulled those off myself.
You did? Okay.
Yes.
So previously, were they in the location they would normally be if the carpet was still remaining?
Yes.
Okay. And you looked at a number of items where there was a red-brownish thing in appearance, and you felt like you needed to do what you called a, what did you call it, a preliminary test?
Presumptive.
Presumptive test, okay. And so you did that at a number of locations on this vehicle, correct?
Yeah, that's correct.
And that includes on A2 that was brought up to you that was a area on the lower plastic molding in the rear cargo area, is that correct?
Luminol would be a presumptive, yes.
Okay. So could you smell the bleach when you reviewed this particular vehicle, do you remember?
I don't remember smelling bleach, no.
Could you see some clear stains, some of which are depicted on this?
Yes,
Did they appear to be consistent with bleach stains based on your observations?
they did.
So if bleach sometimes reacts with luminol, and if you're seeing a bleach stain, why doesn't the luminol do anything in this case if you know?
I don't know why it didn't react.
Okay. But you maintain that your physical observation is that appeared to be bleach stains?
Yes.
All right. Does luminol always react to bleach, or is that something where it is not always happening?
I would say it probably doesn't always happen.
Okay. So for you, it is an indicator, but it is not definitive in your experience.
Correct.
So how many times have you, during your employment, been an individual who was observing stains and having to make at least the most preliminary thought process about whether something is blood?
How many times?
Yeah, how many times do you think you've done this on behalf of the State Crime Lab?
Well over 100 times.
And in that time period, then part of that is because you're trying to figure out, is this going to be tested further, DNA unit, et cetera, correct?
Correct.
Okay. So when you came across A1, is A1 depicted on the exhibit that's up right now?
Yes, it is.
And if the judge gave you a pointer, would you be able Remember those pointers from the old days?
Yes.
If he gave you one of those old traditional pointers, could you point out where A1 is on this particular exhibit?
Sure. Megan.
No.
Okay, so you can go back, thank you, so that you're at a microphone.
Thank you.
So are you the one who placed the sticker on A1 then?
Yes.
So this would be another one of those things that needed consideration for yourself and for Ms. Treffinger, correct?
Correct.
And this was a team approach. You and Ms. Treffinger were trying to consult at times where either of you felt the other's expertise would be helpful?
Yes.
So as to this A1, did you and Ms. Treffinger have any kind of discussion about whether any of the presumptive testing should be utilized on A1?
Yes, we did.
Okay, and why would you need to do that? If the other places you put little tabs were either sprayed or had a presumptive test applied, why would this one be one where you needed to discuss it?
This was a very small stain. As Lisa and I were standing at the back of that van, I was on the passenger side, she was on the driver's side. We were looking in, and we have a height difference. And as I looked, I could see on that molding just this very, very small stain. And as we talked about it, we decided that it was best to just collect the stain so we had all of it, as opposed to trying to take a little bit of it for a presumptive test. It was just very small.
You didn't want to compromise your ability to have the whole amount there to be sure you had the most accurate ability to test.
Correct.
So, did you have an opinion, seeing that item at that location, about whether it appeared to you to be blood?
I did think it was possible that it was blood, yes.
And then, and what did you base that on?
Just my past experience as a crime scene person and what I've seen with blood over the years of working crime scenes. This just had the appearance of it.
So, I guess I need to ask you, as to the other stains that you saw, or the other spots you saw, did any of the others appear to you to also be blood, or was this the one that stood out to you?
I thought the others possibly could be because they had a dark reddish color, but this one did stand out to me.
Okay. And what about it stood out to you? So why, based on your experience, did you say, you know what, these others might be blood, but this one stands out?
Just the appearance of it, there was a little bit more, if I remember right, a little bit more to it. It was a little thicker, but it was so small, and just had the appearance of just a spot of blood.
So let me just show you a close-up of this same picture, if I can.
So this is states 1-315.
And I'm going to bring this even closer if we can magnify this a bit. Okay, so again, looking at this, is that consistent with what you're discussing?
Yes.
Okay. And having been a crime scene analyst, you said you've done this particular profession for 5 years, correct?
More than 5, yes.
At that point, right?
Uh-huh.
Are you still doing it now?
Yes.
So you have an additional 3 years of experience at this since then, correct?
Correct.
Do you have an opinion as to whether the characteristics of what we see on the screen is consistent with items that have been transferred to that location as opposed to have fallen or splashed or something else at that location?
When we talk about transfer stains, we talk about something that may have either been on your hand and you touch an item and it's left behind, or if blood is already on something and you put your hand through it, that's a wipe. The other one would be called a swipe. To me, this just looks like a very small speck of possible blood that was just possibly came off of something. It just got just a little bit of a drip or a splash, but it's not what I would call a transfer stain.
So in your experience, professional experience, it's not consistent with a transfer, with somebody deliberately applying it?
It does not appear to be, at least in that fashion.
Nothing else?
Can you please take down that?
Yep,
Sorry.
apologies.
Sorry. So the stage is focused on A1, but like you said, there were several other areas in the car that you thought could possibly be blood.
Yes.
And there were other stains that had a similar appearance as well.
Yes.
A similar appearance as item A1.
Right, with the reddish brown stain, yes.
No further questions.
Nothing else?
Okay, comment.
The defense will be calling Nathan Hensley to the stand next.
You solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Good morning.
Morning.
Can you please state and spell your name for the record?
Nathan Hensley, Nathanhensley.
And Mr. Hensley, are you currently employed?
Yes, I am.
What is it that you do?
I work in concrete. I'm a concrete finisher.
Very nice. I'm going to just jump right into it. Do you remember talking to law enforcement back in May of 2020?
I do remember, yes.
During that time, where were you residing?
I lived in Wood Creek Apartments,
Do you remember the address?
3709 15th Street, apartment 1A.
Okay, and you said apartment 1A. If you can just explain to the jury kind of the layout of that apartment building.
If you were to walk in the front, it would be the back right corner.
Okay, so did you know where apartment 1B was located?
I believe the front right corner.
So would have been the unit right next to yours.
Yes.
And thinking back to, I know it's a long time ago, but do you remember on May 19th, 2020, speaking with a detective?
I remember one came to our door, yes.
And do you remember being asked whether you were at home on May 17th, 2020?
I don't remember.
Okay. Do you remember providing a written statement?
A written statement?
Yeah.
No, I don't remember that either.
If I was to show you something, would that help refresh your recollection?
Possibly, yeah.
I'm good.
The contents of it, do you remember saying that?
Yes, possibly. Yeah.
And was that, so now that you've reviewed that, do you remember what you told law enforcement about your observations on May 17th, 2020?
I believe I told him I didn't hear anything or see anything.
And was that in regards to the time frame that the detectives were interested in?
Yeah,
And you were home at that time?
I believe so, yes.
And you're saying during that time, so evening hours of May 17th, 2020, you didn't see or hear anything?
Not that I am aware of or remember.
I have nothing further for Mr. Hensley.
Have you take a look at it, just tell me if you wrote it, you know, or if you signed it. What do we mark? 353. So it's not Exhibit 1, it's Exhibit 353. Okay, that I'm going to show you. Can you take a look at that, Exhibit 353? What I want you to hone in on is the signature, and tell me, does it look like that's your signature?
That is my signature.
Okay. Now, is the writing yours in the middle, or did somebody fill that out for you?
That doesn't look like my writing, no.
Okay. But when you signed it, you were saying, best I know, it's accurate, correct?
Yeah.
Okay. So let's first talk about the date that you gave that statement. I assume that the statement you signed was at the same time the cop talked to you? There weren't two different visits, were there?
Not that I believe, no.
So you believe it was just one time you saw the police?
Yes.
Did they come to your place, if you remember?
Yeah, I'm pretty sure they came to my door.
Okay. So if I'm correct, it says it's May 25th, right? Is that the date that's on the statement, down by where you signed it?
Oh, yes. Yes, it is.
So that would be the date that you talked to the police, right?
Mm-hmm.
Yes? You got to say
Yes,
yes or no?
yes, I'm
okay.
sorry.
And they're asking you about, if you look at the top, it says on May 17th. Do you see that?
Yes.
So they're asking you about something that happened 8 days earlier. Is that true?
Yes.
So my guess is that you weren't keeping a diary or keeping track of exactly what you were doing on any given day 8 days earlier. Is that accurate?
Yes.
Okay. Now, it does say it was a Sunday. That helps remind you, okay, so where would I have been on a Sunday evening? Correct?
Yes.
You didn't, at that time, were you working on Sundays?
No.
So that'd be a day off?
Yes.
Okay. And so it says 2000 hours, right? It's kind of military time. Does it say 2000?
Yes.
So they were asking you about 8 p.m.? Is that how you took that?
Yes.
So nobody asked you about what happened at 9:30 p.m.?
No, not that I...
No one asked you what happened at 10 p.m.?
No.
So if something happened an hour and a half or 2 hours later, that you're not talking about that in this particular statement?
No.
Okay. So I guess I'll ask, did you hear anything later in the night either that you remember?
I don't remember.
You don't remember. Fair. So were you living with somebody back in Wood Creek there?
Yes, my girlfriend.
Your girlfriend. Okay. So tell me what a Sunday night would have looked like. TV, music, computers, were you guys gamers? What do you think, what would be your best help for us on what you would have been doing at 10 p.m. on a Sunday back in 2020?
Either TV or movie or sleeping. Yeah.
All right. Sleeping was in the picture even at 10?
Yes. Yeah.
All right. If you were asleep, you wouldn't hear anything. That's fair? Or unless you could wake you up, but otherwise you wouldn't.
No, it wouldn't wake me up, no.
What?
I'm a heavy sleeper. So,
Oh, you are?
Yeah, no.
I think I'm going to end with that. Thanks very much.
Nothing further.
Have it down, sir.
I guess I'm going to move admission of the exhibit.
No, I would,
You don't want it in? Okay.
No, it's- I don't
Then I
think it's
won't.
appropriate.
Yeah, you can hand it to me. Thank you. I guess we'll keep it as part of the record, though. Thank you.
the defense will call Jennifer Ziegler to the stand.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please be seated.
Good morning, Miss. Is it Ziegler?
Ziegler, yes.
Ziegler. Can you please state and spell your name for Madam Court Reporter?
Yes. Jennifer Ziegler, Jennafer, Ziegler.
And are you in a relationship or residing with an individual named Nathan Hensley?
Yes.
And for approximately how long have you resided with Mr. Hensley?
A little over 4 years.
So back in 2020, were you residing with him?
Yes.
And I'm going to give you a specific time frame. In May of 2020, do you remember where you were living?
Yes.
And where was that?
Wood Creek Apartments.
And do you remember your specific address?
I think it was 3709. I don't know. I don't remember the street. Sorry.
If I said 15th Street, does that sound right?
Yes.
And do you remember your apartment number?
1A, I believe.
And so in Wood Creek Apartments, while you were living there, did you know an individual named Mr. Gutierrez?
No, not personally. I knew him after everything kind of happened. I guess I heard of him.
Okay. And do you know where apartment 1B was located in relation to your apartment?
Yes.
And where was that?
So it would be right next to us, basically. Yeah, to our left.
Okay. So I want to jump back to May of 2020. May 17th of 2020, it was a Sunday. Do you have a recollection now, I know it was a while ago, about what you were doing on that date?
If it was a Sunday, I probably would have just been at home, or maybe I was with my parents away at their house, so it would be either or.
Okay. Do you remember speaking with detectives in this case?
Yes.
And you spoke with detectives on 2 separate occasions. Was one, the first time that you spoke to a detective, was that because they came to your house or your apartment, or did you go to the police department? Do you remember where that conversation happened?
Yes, they came to my apartment.
And was that the day where there was a lot of law enforcement there?
Yes.
Okay. And you remember seeing all of that?
Yes, I do. Yeah.
Okay. And do you remember what the detective asked you?
I think he kind of asked me like if I seen or heard anything.
And would that have been for that Sunday, May 17th?
Yes.
And what did you tell the detective?
I'm pretty sure I told the detective that I did not hear or see anything.
And was that accurate?
Yes. Yeah.
And were you then home on May 17th, 2020?
Yes.
And for that entire evening?
Yes, I would have been, yeah.
And that entire time, you didn't hear anything?
No.
Or see anything?
No.
And now, thinking back to when you were living in Wood Creek Apartments, if there was a very loud noise or someone screaming or yelling, would you think you'd be able to hear it?
Objection seems like it would call for speculation.
Kind of sounds that way.
from when she lived there, her own observations, if she could hear things that were loud.
Everyone's.
If you can't hear, then you don't know that you're not hearing.
Right. Do- okay. Have you heard people arguing or screaming before in Wood Creek Apartments?
Arguing and screaming, no. I heard footsteps. I hear footsteps and stuff like that, like doors shutting and stuff like that, yeah.
And so thinking back to May 19th when you were giving this statement, if you even heard things like that, you would have told law enforcement?
Yes, yes.
And you didn't hear anything of that sort?
No.
And I have nothing further. Thank you.
Any redirect?
Ms. Ziegler, so you,
Yes.
Ms. Ziegler, you believe that at first somebody spoke to you while the cops were still around?
Yes.
So were you not working during the day?
I worked Monday, Wednesday, Friday, so Tuesday and Thursday I was off. So I'm assuming it was on one of those days.
Okay. And so you were home when they came and asked?
Yes.
All right. And were they, to your mind, were they asking about something that had happened the night before, or did they, I'm talking about the first time they talked to you,
Yeah.
or were they talking about a specific different day?
It was a different day. It wouldn't have been like that day.
Okay.
Yeah.
So so if the cops were still there and they were asking you, how do you have any idea how they would know which day to ask you about at that point?
I'm going to object. Calls for speculation.
She
Yeah.
knows. If she
Yeah,
knows.
I don't know.
Okay. So, but then at some point you also were asked to give a written statement, correct? Yes? You got to
think
say
so.
yes or no for the record. You can't just say.
Yes, sorry. Yes.
And at that time you were again asked, and they asked you about a specific day that time, didn't they?
Yes.
Okay. So I'm going to show you. First I got to get it marked.
Yeah.
So I'm going to show you what's been marked as State's Exhibit 354, and the first thing I want you to do is look at the bottom of this and just tell me, do you recognize your signature? Okay. And you can hold it.
Okay. Yes.
Okay, so is that your signature?
Yes.
Okay, so when you signed that, were you trying to report everything you knew based on what people were asking?
Yes.
Okay, so is there a date by where your signature is that says when they were asking you about that? So you know what date they were asking? In the area where your signature is.
Yes. I see a date right under.
And so what is that date?
5/25/2020.
Okay. And so, and then in terms of what time they were asking about, date and time, is that at the top of the document where it says on May 17th, 2020?
Yes.
So that'd be 8 days difference, right, in terms of this statement?
Yes.
Okay. And on Sundays, you didn't work?
Yes.
Okay. And were they asking you, based on the military time they wrote down, did it look like they were focusing on 8 p.m. on the evening of May 17th?
Yes.
Based on military time. It says 20, right?
Yes.
00, which would be 8 p.m.?
Yes.
Okay. So I want to actually ask you about a couple hours later on a Sunday, okay? And whether people maybe were headed for bed and things like that a little later. So by 10 p.m. on a Sunday, do you remember whether you guys would be in bed yet?
Yes. I go to bed early, so.
Good. Okay. And so if I told you it was at 10 p.m., would you expect to hear things out in the
I'm
hallway?
going to object to speculation.
Well, I didn't hear the whole question, and it smells that way.
Yeah, well,
But you used the word expect, so
yeah.
you can complete your question, but you're on borrowed time.
It's not the first time. And the court has allowed me to pay up on those borrowing a couple of times. So my question is, if it was at 10 p.m. on this Sunday, what, if anything, can you tell us about how that would impact your ability to hear things in either the hall or the neighboring apartment?
Yes, because we sleep with a box fan, so we wouldn't be able to hear.
I think I'm going to end there, Judge.
I do have some redirect, Judge. Thank you. You talked to law enforcement twice.
Yes.
So the statement that Attorney Gravely was just going through with you, that would have been the second time you talked with law enforcement?
Yes.
And thinking back, if they were detectives asking you about that entire evening of May 17th, 2020?
Yes.
And if you were sleeping and you knew you were sleeping at that time, would you have told law enforcement that?
Yes. Yeah.
Nothing further.
Well, you're saying that if you went to bed sometime on the evening of May 17th, you would have told the officers I went to bed?
No, sorry, no.
Okay.
No.
Nothing else?
Very, very limited. You told them you didn't see or hear anything.
Yes.
And it wasn't because you were sleeping. Let me rephrase that. If you had been sleeping, would you have told law enforcement, I was sleeping, so would not have been able to hear or see anything?
I just told them I just didn't hear or see anything just because they just asked if I heard or saw anything that day.
And thinking now, can you remember if you were sleeping or not?
No, it was 3 years ago.
Okay.
But I would be sleeping because I go to bed at 9 p.m.
At 9 p.m.?
Yes.
Okay.
And I've been going to bed at 9 p.m. because I wake up at 5.
Nothing further.
Nothing.
You may step down. Give it to the district attorney when you walk by, if you would, please.
The defense would call Kim Lavora to the stand.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Good morning.
Good morning.
Could you please state and spell your name for the court reporter?
Sure, Kim, K-I-M, Lavora, L-A-V-O-R-A.
And Ms. Lavora, is there another first name that you also have?
Yes.
Could you please state and spell that also?
Sure, E-U-M-D-E-U-N, Umdian.
And is it okay if I just refer to you as Ms.
Yeah.
Lavora? Okay. Ms. Lavora, are you currently employed?
Yes.
And what is it that you do?
I'm an accountant.
Where?
At Wacker-Newson.
Okay. And how long have you been employed there?
It will be 10 months.
Very nice.
Sorry.
No, you're fine. I want to kind of jump back in time to May of 2020.
Sure.
And during that time frame and before, did you know an individual named Rosalio Gutierrez?
I only know him through text.
Can you explain how you know him in as much detail as possible?
Oh, sure. I was on a Facebook dating site, and then he liked me, and we started conversating through text only. Had a few texts. I felt like I felt nervous. I never met him. We talked every day. We text every day. He told me personal things about him, his daughter, his business. Moving forward on to May, he told me that he was going to Menards and picking up his daughter, and then the following days when it happened.
So I wanted to go back a little bit. When did you first, if you remember, when did you first start talking to Mr. Gutierrez on Facebook dating?
Maybe February, because it was really short. It was only for a few months.
And from the time that you started talking to him to about May, let's say 18th, 2020, what was the frequency of your communication?
Texting. We would text frequently every day. When I got off of work, I would give him a phone call. We would talk about an hour or two, and then I didn't talk to him for the rest of the night. And then it would continue the next day.
So not only just texting, but also phone calls?
Correct. He wanted me to meet up with him in Kenosha, and I said, no, not today. No, it's not today. My gut told me no, so I never met him.
And when you're talking about all this talking and calling, what was the nature of the relationship? Was it just friendship, or was it more of a romantic relationship?
No, for me, it was just friendship. He wanted probably to take a step further, but I wasn't comfortable with that. So that was it. For me, it was strictly just friendship.
But you're saying for him,
yeah,
it seemed that he wanted more?
Yeah, that is correct.
Okay. And jumping to May 17th, 2020, do you remember having a phone call with Mr. Gutierrez?
If that was a Sunday, yes.
It was a Sunday. I'm going to show you what's been marked as Defense Exhibit 75. So it's just going to pop up on the screen. Okay, I'm going to zoom in here, the highlighted portion. Does that appear to be the phone call you remember having?
Around what time?
That says 8:49 p.m.?
Yeah, kind of. It was night. I know it was night. It was dark out.
Okay. And that's your phone number?
Correct. Mm-hmm.
So that 414-334-1158?
Correct. Correct.
Oh, sorry.
Oh, sorry.
That's your number, this date, and it says that phone call was about 17 minutes. Is that how long you remembered it being?
Yeah, because he was saying he had to run errands, go to Menards, pick up his daughter. He was like, when I get home, I'll give you a call. And he never returned. He never called me back. And then when I called him, probably a couple hours later, the phone just kept ringing and ringing and ringing and ringing and ringing.
So after you get off the phone, after the 17-minute conversation, you said he told you what he was going to be doing the rest of that evening?
Yes.
And can you say what that was?
Oh, and hold on for just a second. Objection, it's hearsay. What he told her on the phone.
Why would it not be?
would just argue that it was just the impression on Miss Lavora about what she thought he was doing, not offering it for the truth of the matter asserted.
What difference does it make what she thought?
That's the defense's position. I have nothing further, Judge.
Do you have any other questions?
No, I'm objecting based on hearsay.
Well, I have to say the sound is so bad in here.
Yeah.
I thought she said that is the defense's position, nothing further, Judge, which I thought was the end of your examination.
Maybe it was.
Maybe you
No,
just
it
didn't
was
want to haggle with me.
nothing further on our position on the objection.
Okay. Let's take a break. Please don't talk about the case during the break. Read, watch, or listen to any account. And 10 to 15 minutes. Please. You were a new witness, yeah. We're ready to roll.
Okay.
Okay. Stage.
Thank you. Ms. Lavora, you indicated that approximately when did you start speaking with Mr. Gutierrez?
For a few months, probably estimate maybe February.
And you consider this a friendship, is that accurate?
Yes.
And is one of the things you bonded over how close you both are to your respective children?
I think it was just more of common daily activities, I guess, children, food.
But did he speak to you a lot about his children?
Objection, relevance.
He said he had.
Hold on a minute. Just please. What's relevant?
One of the things the state has to prove here is Mr. Gutierrez has gone through this witness in terms of their conversations about what is important to them. It's just seeking if that was something that was important to him. It'll be brief. Thank you. Did he speak a lot about his children and their activities?
Generally, not specifically, no.
Did he explain about how active a role he took in baseball with his son or gymnastics with his daughter?
Gymnastics, yes, and softball, baseball, correct, yes.
And you indicated that through May 17th of 2020, you guys were in communication daily, multiple times a day?
Correct.
And after your phone call with him on May 17th of 2020, did you ever hear from Mr. Gutierrez again?
After that phone call, no.
And after you didn't hear from him when he was supposed to call you later that night, did you then try to reach out to him multiple times to...
Correct, yes.
And were any of those ever answered?
No.
did his phone start going directly to voicemail?
It started ringing continuously, a couple times, and then it went dead. So.
And during your friendship with Mr. Gutierrez, was it unusual for him not to get back to you in a timely fashion, given how often you guys spoke?
Yeah, that was very strange.
And ultimately, because you were someone that was in Mr. Gutierrez's phone when that scene was found, did you speak to law enforcement about your friendship with Mr. Gutierrez?
Yes.
And did you offer to them all the information you had regarding anything you knew about him?
Yes, I did.
And in fact, during your time of talking via the phone for those couple of months, there were times you were actually in Kenosha physically and you two did not meet up, correct?
I was never in Kenosha.
Oh, you never met up in Kenosha?
No.
Okay. So you and Mr. Gutierrez never had any plans to meet up as of May 17th, 2020?
He wanted to meet up, but I never went.
I have nothing further. Thank you.
Cross?
Nothing further on redirect. Nothing further, Judge. Thank you.
You may step down, ma'am.
Oh, okay. Thank you.
Judge, at this time, the defense would like to make argument. We have witnesses. There was a development where the state had talked to an individual today. Sure. So we don't have witnesses ready now because of the development until the afternoon. So we're hoping to take this time to make the arguments that we would have made earlier and to instruct the court on where we're going to be moving forward.
Would it be convenient to break until 12:30? I get wagging of the head. Is that, no, it wouldn't be, or? What did you say? Ah, bless you. You have no idea how wonderful you people have been.
At this point, they're sort of captives, Judge. So we're.
Well, I know it, but they could be owly too, and they're not. I mean, I've had cases where the jurors just glared at me. Anyway, let's break and come back at 12:30. Please don't read, watch, or listen to any account of the trial. Don't talk to anybody, including fellow jurors or household members, about anything about the case. And 12:30. All right. Did permit the defense to reserve motions at the close of the state's case. So I think, Mr. O'Berry, you're on the floor.
Your Honor, thank you. Your Honor, at the close of the state's case, it's required under appellate case law and for the defense to make a motion generally as it relates to whether or not the state has presented enough evidence that any reasonable jury could find the defendant guilty. And what I want to do is talk in particular about, and I'll start with count 2, because there is a failure of proof with regard to that charge. That is the stalking, where Rosalio Gutierrez Jr. is the victim of that. And as the court is well aware, when we look at the jury instructions for stalking, it is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to either suffer serious emotional distress or to fear bodily injury or death to himself or herself, or a member of his or her family or household. And that would cause a reasonable person to, again, either suffer serious emotional distress or to fear bodily injury or death to him or herself or a member of his or her family or household. And where the actor knows or should have known that the conduct would cause that person to suffer serious emotional distress or to place the person in reasonable fear of bodily injury or death to himself, herself, a member of his or her family or household. So the state has presented no evidence at all concerning Mr. Gutierrez either perceiving such a serious, and again, it's not just any emotional distress, but serious emotional distress, and or anything about bodily injury or death, any apprehension of that. Of course, another way that that can be brought in is if it would have, well, a second element actually is that it would have caused a reasonable person to have those same beliefs. The only evidence that has been introduced at all regarding the effect of these activities on Mr. Gutierrez himself was specifically that he was not afraid of Mr. Anderson in any way. In fact, there were some, we might call, jousting, not afraid of this guy type stuff. And there hasn't been any evidence presented by the state that would fit those elements as it relates to Mr. Gutierrez at all. So the fact that there's no proof on that element that's been introduced by the state, that should be a directed verdict of not guilty. Now, I want to talk about count 1 because there was some evidence that was received relating to Ms. Beecham's apprehension of emotional distress. There was one point where she testified that she was, quote, fearful. There was also evidence introduced surrounding all of the other circumstances, how she felt in response to it, what her reaction was, and things she did in response to them. Now, it's important to note that when we have, and I'm going to make an analogy here to the law that we understand as it relates to simple disorderly conduct, and you'll see why in a second. Because as we know, there's activity that we as a society are willing to tolerate within the bounds of normal and sometimes difficult interactions between human beings. And the court's well aware disorderly conduct is an example of that because it has to rise to a level where it's outside the scope of what we would consider to be tolerable activities, given the fact that people do have difficulties in life and sometimes do express themselves in ways that don't rise to that criminal level. So complications and arguments and some jousting going back and forth, some argumentation going back and forth, practically all of which was in the context of the children, but also what could probably be characterized as just normal friction that goes on when there's the ending of a relationship. The fact that Ms. Beecham had, and as she testified in the stand, at one point she did use the word fearful, but there was no evidence that this was serious or severe emotional distress, and no evidence that she was fearful for her actual safety or life. So, taking the evidence as a whole, there is not, in our opinion, sufficient evidence that any reasonable jury could find Mr. Anderson guilty on count 1 either. And again, I acknowledge that there was one statement where then she used the word fearful, and that was all she said. Now, the most complicated aspect of this case, of course, is the fact that the state has charged in count 3 first-degree intentional homicide, and of course that relates to causing the death of Rosalio Gutierrez Jr. with intent to kill that person as a Class A felony. The state has established, I think it's reasonable to state, and a reasonable jury could conclude that he is at least missing, and it's not an illogical step for the state to argue that he is in fact dead under the circumstances. So we acknowledge that. But the fact that, and Mr. Gravely himself put on a great deal of evidence about how extensive the investigation, all the different places that they looked, and one would have to believe that with all of those resources at the state's disposal, that something more would have come up. So I know this is very difficult to quantify in any particular way. There's no mathematical formula here, but the state would ask, the defense would ask the court to determine if the state has met that threshold as to whether or not the state has produced sufficient evidence that would enable a reasonable jury to render a guilty verdict at that point. And the same argument really goes for count 4, because acknowledging that there is evidence that could be perceived as somebody removing a corpse if the person was dead from the apartment and then doing something with it. The only real evidence of that is the missing rug, the amount of blood, and arguably this other spot that was in the car. And assuming, of course, that the cutting out of the rug is something that the state believes that they've established timeline-wise. So again, hiding a corpse, there isn't a corpse, and it's again one of those complicated situations that the defense would ask the court to determine if a reasonable jury would be able to find the defendant guilty of that count. So with regard to counts 3 and 4, I think those are pretty much traditional arguments that the defense makes in these types of situations. But I, again, on count 2, would emphasize there's been a complete failure of proof on the elements of causing Mr. Gutierrez to suffer either serious emotional distress or to fear bodily injury or death. And then, again, with regard to count 1, relating to Sadie Beecham, that with the exception of her use of the word fearful, which we'd argue doesn't rise to the level of serious emotional distress, there's been a failure of proof with regard to that as well, and we'd ask the court to direct a verdict with regard to that as well. So we're asking for directed verdicts on count 1 and 2. We're asking the court to dismiss counts 3 and 4 on the basis that the state hasn't produced sufficient evidence to enable a reasonable jury to come to the conclusion.
Thank you. State?
Judge, I'm looking at the stalking instruction. I'd like to start with that. So I'm looking at the jury instruction itself. Page 2 of the jury instruction defines suffers serious emotional distress. It does include what counsel mentioned, which is to feel terrified, threatened. Those things are included, but unfortunately for the defense argument, it also includes harassed in that definition. So again, that's the bracketed definition of suffer serious emotional distress in jury instruction 1284, which is the official jury instruction for Wisconsin for the court to read for stalking. So in this case, certainly both of the charged persons who are victims, alleged victims in this particular scenario, would have reason to feel harassed by a series of incidents. And as the court knows, in terms of a venue statute, if any one of the requisite acts occur in your county, then you may use other counties' acts as a portion of that venue. And in this case, the course of conduct required by stalking is at least 2 acts. We have alleged and have now abundant evidence from the state's perspective that on April 25th, the defendant at the home of Sadie Beecham, so that's not in Kenosha, but would be in terms of the course of conduct, something that meets the venue statute, that he peeped in a window, observing both Sadie Beecham and Rosalio Gutierrez, and that he broke into and took items from the truck of Rosalio Gutierrez. I think the court has heard the evidence of that, including that documents that are consistent with that were brought up to Sadie Beecham, that there's on the defendant's phone, there's a picture that can only really be explained by his removal of an item from Rosalio Gutierrez's truck. And the defendant himself has admitted to various parties that he peeped in the window. That was even brought up. He admitted that to law enforcement and observed those two persons. So that certainly would cause any individual to feel harassed at the very least. The defendant then, on May 8th, plants a phone in the car of Sadie Beecham. That car comes down to the Kenosha address of Rosalio Gutierrez. Again, that's done for purposes of essentially harassment and monitoring, which is again harassing, and that's harassing to both of the two individuals. And then on May 13th, we provide evidence that the defendant is again eavesdropping, at this time in Kenosha, at the home of Rosalio Gutierrez. Not only does his phone place him in Kenosha at that time, but it's the very same phone that is using to text Sadie Beecham. So she's literally inside the house of Rosalio Gutierrez in Kenosha. The phone of the defendant is in Kenosha, based on the evidence the court's heard from FBI agent Hannah Judd. From that same device, he is texting the exact words that Rosalio Gutierrez has just uttered. Again, this is communicated to Sadie Beecham, so this is the defendant wishing that to be communicated. And so, again, is a second incident of eavesdropping, not at Sadie Beecham's home, but at an individual's home in Kenosha. The court heard both of these individuals express distress in various ways. Again, it's a reasonable person standard. Would a reasonable person who has had a phone placed in their car and who has been peeped on twice in a 3-week period feel harassed? Would that be what a reasonable person would believe? And I think that there's a simple answer to that, what a person of ordinary intelligence and prudence would consider about that. And in fact, the defendant only has to intend directly to broadcast one of those, per the stalking jury instruction. So as the jury instruction ends, it says that the defendant knew or should have known at least one of these acts constitute a course of conduct, again, that would cause someone to feel harassed based on what I have just described to the court. Well, each of these would be something that a reasonable person would believe would cause someone to feel harassed. So, again, I think we've met the stalking statute as to both. And again, Rosalio Gutierrez mentions to at least one friend that's in evidence, hey, this is happening to me. Certainly there are a number of texts between himself and Sadie Beecham where they express significant concern about what's happening. Rosalio Gutierrez even talks about, having a confrontation with this individual. This was abundantly presented in cross-examination in this case. And that is a sign of an individual dealing with feeling harassed in a situation. It's a very logical reaction to feeling like some person you don't know is harassing you. So that I think that there's abundant evidence of stalking as to both of those two per the presentation I've just made. As to the homicide, I'll go right to the element of causing the death. The court has now heard 3 members of the Wisconsin State Crime Lab. I think I count over 40 total years of experience in crime scene investigation and blood evidence from those 3 individuals. The court knows the State Crime Lab have many of the preeminent experts in this area in our state. They have all offered the opinion that this particular thing located in the defendant's van, simultaneous with seeing that shortly before, per the evidence in this case so far, his van has a cutout section that would be an area sufficient to store the body of Rosalio Gutierrez, at least for a short period of time. And there is blood found in that van, and that blood is in fact the DNA of Rosalio Gutierrez. So to transport the blood of Rosalio Gutierrez away with the strong evidence of motive, with all of the other things that we've talked about happening on April 25th, the 8th, and the 13th, and then with the significant deception that the defendant engages in his interaction with law enforcement on May 19th, combined with the rest of the evidence we've presented in terms of circumstantial pieces, From the state's perspective, we have provided sufficient evidence for any reasonable jury to conclude a homicide has occurred. Thank you.
Thank you.
Just briefly, very quickly, Judge. The argument that Mr. Gravely just made with regard to the reasonable person aspect of stalking only relates to element 2. That is, the course of conduct would have caused a reasonable person to either suffer serious emotional distress or to fear bodily injury, etc. But the important thing here is element 3 is that the defendant's acts did cause that person to actually suffer serious emotional distress, induce fear of bodily injury or death. So that's what we're missing here, is that there's been no evidence of that.
Well, again, the definition of suffer serious emotional distress, which is located in 2 and 3, is the same, which is harassed, which includes the subsection harassed.
And again, just briefly.
Well, no, that's your point. You're combining the act with the cause with the effect. You're merging them into one concept.
But the definition remains the same.
Oh, I'm not arguing that.
So yeah, you both have to, the conduct and the result, but the result is the result of the words suffer serious emotional distress can include that the individual involved feels harassed.
But that still doesn't cover both elements that we're talking about, 2 and 3. Really, well, logically speaking, the reason why element 2 exists is that we're adding a reasonable person standard on top of the actual causation that's represented in element 3. So presumably there could be a situation where somebody is overly sensitive and wouldn't be that reasonable person standard, which is why the state has to prove that additional aspect of it. But also, I think it's a leap to say that eavesdropping on somebody is harassment, and that's essentially what the state is saying. But checking in on the mother of your children and see what she's doing that doesn't rise to harassment necessarily.
I don't know about that. I'm not having such trouble, but I guess I think there's a step being skipped here. In merging the cause and the effect. The cause is harassing behavior by the defendant, and I think that there's evidence there from which the jury could conclude that element is present. The defendant's argument, as I understand it, is that where's the evidence that the defendant's acts had the effect of inflicting
one of the subsections in 3 is caused Rosalio Gutierrez to suffer serious emotional distress.
Right.
So yes. So the second element here is what would a reasonable person be feeling out of this, right? That's the second element. The third element is what did the named victim feel out of this? But the definition remains the same. That when you opt for to suffer serious emotional distress, whether you're speaking about the reasonable person or you're speaking about the victim themselves, right? It's still the same definition of suffer serious emotional distress. It's just all that happens in those change of elements is what would a reasonable person feel, and then what did the purported victim feel. In this case, the way you do that, you can't read the mind of individuals, right? We know this, right? In all instructions, it's from the acts and circumstances, particularly when you have a deceased person, right? So, otherwise you would never be able to stalk a person if you managed to murder them. You'd never be able to do it, right? So the third element here is what impact did this have on Rosalio Gutierrez? And within the definition of suffer serious emotional distress, one of the options is did he feel harassed? Okay, so what is the element? What are the pieces of evidence he felt harassed? Well, he told an individual that he felt that this person was a problem. And if the court remembers, the court limited that evidence on various times. We described that we were wanting friends of Rosalio Gutierrez to talk about how he had identified an individual who was a problem for him. But we did manage to get one individual to be able to say that. And in their text messages back and forth, which were covered extensively, Judge, it's clear that Mr. Gutierrez is feeling harassed. And I told you, I think the most clear answer about that is the way he is planning on solving the issues that are related specifically is he's thinking, I will go over there. He does as much as collect the address of this individual. And I think that's the most rational and logical way that one would respond. So elements 2 and 3, the only change is what is a reasonable person going to be impacted, and then element 3 is how about the victim himself. But it's the same definition of suffer serious emotional distress. So certainly a reasonable jury could say, based on the facts we heard, Rosalio Gutierrez is someone specifically who would feel harassed here.
If I may.
Well, they didn't. The legislature did not use, or at least, this is the legislature. This language is taken from the law itself, not just a pattern instruction from the committee. But they didn't use the word annoyed.
Didn't use what word?
They didn't use the word annoyed.
No, they didn't. They chose harassed.
They chose intimidated, threatened, terrified, harassed, or tormented. Now, we had a case in here a couple of years ago. Not you, but a couple of people from your office, and the prosecutor. Well, all of our names who were involved in the case. Our addresses were published on the internet. My children's names were published on the internet. What the goofball thought were my children's addresses were put on the internet. All wrong. So I was annoyed. I cautioned my family. I made them aware of the situation, but in the case of at least one of your assistants, the correct information was published. And you know what he went through. I don't actually know what his reaction was. I know what a reasonable person would have felt. Terrified, intimidated, threatened, tormented, and harassed. That's what the reasonable person would have felt. And if you told me that he was any of those, I would say it makes sense to me. And I think the significant difference is that in my case, I knew the information was faulty, so I was still very annoyed, but I would not qualify myself as having fit into those categories. So it depends somewhat on the nature of the provocative behavior. And the question is not whether, there's I won't talk about your assistant, or I won't talk about myself, but there are people who would react to that by searching the person out and beating the living daylights out of them. Happens all the time. That's our business, that we deal with these types of cases on a daily basis. So I'm not sure. Terrified, intimidated, threatened, maybe harassed, tormented.
This person was.
You're talking about now. We're not talking about the reasonable person. We're talking
I
about
understand.
Mr. Gutierrez, and so if that element were written as being annoyed, I would quickly dispose of this motion.
He's peeped on twice. So within 3 weeks, he is inside the privacy of someone's home, their castle. Okay? And a person who does not have a right to look in the window, make observations, and then taunt individuals outside does those things, Judge. That's the allegation here. 2 separate times in 2 locations, he is eavesdropping on private conversations inside the home. This is I would say to you that's the definition of harassing someone. That is the definition of harassing someone. If somebody was outside your or my window when we were in the privacy of our own home, and they were then communicating to people that we were close to and saying, here's what I'm observing in there. Here's what you just said inside your house.
Yeah, that would prove what a reasonable person's reaction would be.
But this is a deceased individual. So how, I mean, so the court knows that those things occur.
I can't presuppose that, by the way. I'm not the jury.
We cannot look into the mind of an individual in this situation. We cannot do that. So except what I've told you already, what I've already shared with you, which is we've shared extensive email information back and forth where he and Sadie talk about how the stress of this particular experience, right? They're communicating about this. And Rosalio Gutierrez's reaction, shared with the jury, is, I think I'm going to take care of it. I think I'm going to go find this guy. I'm going to deal with him. And they even have a conversation revealed in the text messages about the address. So the court indicated, well, if someone shares your information on the internet, that might be your same situation. Yes. But the added information the court has is that what Rosalio Gutierrez knew at the time was that his information was he had been literally peeped on twice in private residences where then the information obtained in that peeping on him was being used to taunt people. And I'm not even talking about breaking in his vehicle, which of course is something that is a worry as well, private information. Right? So, for instance, what happens is a letter is taken from his vehicle, and that letter is utilized to try to indicate that Sadie should be watching out because he's actually in some other relationship. It's being used in a way to try to harm Mr. Gutierrez.
The statute deals with effect, not cause. You're talking about cause.
Right.
You're talking about effect on a reasonable person, and the motion, as I understand it, is the effect on Mr. Gutierrez. He's dying to talk again, so I'm going to let him.
And I'm being so patient, Judge, because I didn't want to interrupt Mr. Gravely. But I'll quote from a very significant text from Mr. Gutierrez. I'm not worried about it. That's exactly what he said. And the argument that one is guilty of stalking, and the most compelling proof of that is the fact that Mr. Gutierrez wanted to beat down Mr. Anderson. That's stalking. I mean, so that he had a reaction like, I want to take care of this, I want to deal with it, and simultaneously saying, I'm not really worried about it. I think the court's right. It may be something that one gets annoyed by, which is why I had the discussion about for something to rise to the level where it's criminal conduct, this type of criminal conduct, that it needs to be, an actual effect of harassment. And the most, I get a bunch of fancy arguments here about how, and again, he's focusing on reasonable persons, but we have evidence that it didn't bother Mr. Gutierrez from his own words, and in fact, one could glean that he almost found it amusing that he was going to break his legs or call somebody up to do something to him. But you can't prove that one's harassed because they want to beat you up.
Well, I think that I cannot, and I think this is the appropriate test. I can't exclude the possibility that the jurors will see it as Mr. Gravely does, and that a reasonable jury could come to that conclusion. When you use the word terrified, as the statute does, that kind of shoves aside a reaction like, I'm going to go confront the guy and I'll take care of this. That to me is more the reaction of an annoyed person rather than a terrified one. But it's not. I'm not so sure of that I would grab the issue away from the jury. So I'm going to deny your motion.
Right. And just so the court, the subsection says or. What? So terrified is one. But thank you.
Yeah, wrong way.
Thank you.
I just think the court denies my motion, but he still has to add something to it.
We're
done.
Now, come on now, let's play nice. And your other motion with respect to the fourth count, did you make some comment on that?
With the hiding corpse?
Yeah.
Very simply that, we don't have a corpse, and I know we don't have to have one, but the evidence of, again, the aspects of that, similar to count 3, I simply asked the court to analyze the evidence as to what evidence there is that a reasonable jury could find that Mr. Anderson himself, as opposed to anybody else, hit a corpse with the intent to avoid apprehension for a crime. And I acknowledge that there was, if there is a corpse, if there is a death, which I know that the state has to prove that as part of this, but even supposing that, I'd ask the court to make that determination. I'm required to make the motion in any event.
Well, if the jury is satisfied of the state's proof on count 3, then there was a body, and it's gone, and there's evidence from which the jury could conclude that it was the act of the defendant that led to the removal of the body. So, motion is denied. What else?
That the defense wanted to just inform the court of where we are witness-wise for the remainder of the day. There was a development where the state had talked to an individual, and that nixed the necessity of 3 witnesses we had lined up for this afternoon. So now, instead of having 6 witnesses for this afternoon, the defense only has available 3. However, we believe that those 3 will take up this, if not the whole afternoon, the majority of the afternoon. So that's the 2 witnesses who are in custody, Marquand Washington and Nicholas McAtee, and then we have an officer witness available to testify after that. As far as the other witnesses, due to their commitments and availability, we have them all lined up for Monday. And we have a remainder of, I believe it will be 8 or 9 witnesses for Monday. And so given that the majority of these witnesses are short, we would expect to rest on Monday afternoon.
Well, do you have comment, by the way?
No, I appreciate that counsel has tried to keep me appraised of our developments, and so and that is why we were able to remove 3 witnesses. So I mean, I guess I want to tell the court I think that development was a positive one. When we interacted, we were able to check some things that I think allowed them to not need to call those witnesses. So no, I think that is the current schedule, and I defer to them about how many more witnesses they have or where they think the schedule will take us in terms of Monday.
Well, first off, the last word spoken in this courtroom this afternoon will be at 4:30. That is the last word in this courtroom this afternoon.
Meaning we're not going past that, is what I think the court said.
You are so right.
But that doesn't think about what happens if we're done at 4 and they have no further witnesses.
You know what? I'm not going to go to the complaint department if you.
Very
want.
good. Okay.
But just so you know, you're not.
Nothing past 4:30.
The muzzles will go on at 4:30.
Gotcha.
That's number one. Number two, no matter how many witnesses there are on Monday, and you tell me that you consistently refer to short witnesses, and we've had a few. I think you mean brief. No matter how brief they may be ready for instruction, and I do instruct first. Be ready for instruction on Monday, which is why any requests that you have on verdicts or instructions will be due at, what did I say when we were talking?
Said 5 o'clock Sunday.
5 p.m. on Sunday. 5 p.m. on Sunday. Send it to my email that you've gotten on prior communications. And, of course, send copy to the other side. And you can list the instructions by number unless you have changes. If you have changes, you need to set forth the full change you want. And highlight the differences between the standard and what you want. Sometime before noon tomorrow, I hope, this is not for sure, but I will hope to send you a preliminary draft of the boilerplate stuff.
And if the boilerplate stuff is what we anticipate, then we do not need to communicate with you at 5. If we have no different...
Just tell me you're comfortable with everything.
Very good. So you still would like us to communicate and say something. Got it.
Recommendo.
And just so I make sure I'm understanding everything, if we're just asking for the standard instruction, we can just simply include the number. It's only if we're asking for a change to include that and the difference.
That is correct, and I did mention when you were up here before that I don't, the statute I think is a little difficult to work with in terms of making a fully intelligible statement to the jury of what exactly needs to be proved. So while I'm not demanding it of you, the form that was in the preliminary instructions, which I will repeat in the ones that are sent to you over the weekend, that follows the what's in the information. And I think it's awkward, but if both sides are comfortable with that, far be it for me to jazz around with your case. Was there something else? I don't think so. Anything else from you folks?
We're back at 12:30.
Well, can we have lunch? I mean, we can't go get lunch and be back by 12:30. It's impossible.
Well, there's fast food available. Yes, and you can even have meat if you like. All right.
So what time should we be back?
12:30.
Okay.
No, the jury's been so good.
Yeah.
And I feel like such a traitor if I give you more time than I give them and have them sit up there in the dungeon. I probably won't lift my voice if you're here by 12:40. Okay?
Thank you, Your Honor.
Now, let me just ask this, is there a medical reason why you need longer? Oh, okay. No, you have to eat, but I just... Pardon me?
Gotta wait for Attorney Birdsall.
I did not. I didn't realize it was going to.
I think that's what we are hoping to argue next.
Oh, well,
So-
give me a moment.
So it'd be a good, this would be a good time, Judge, if you have the time.
They keep adding stuff to my pile here.
So there's a
No, I
report
agree with you. I just wanted to
from
try to-
Badger State Investigative Services, and then there should be 2 copies of criminal complaints.
was supplied. What's up?
So, Judge, those are our witnesses, and we're recalling Mr. Washington, and then we're going to confront him with some of the statements that Mr. McAtee stated in that investigative report that you just read. And what we want to do is then call Mr. McAtee, and I can anticipate the objections, but it's well founded that this is just bias evidence, and that it's very clear that, according to Mr. McAtee, that this was an invention of Mr. Washington's to help himself in his federal case, and we want to present that as exactly that. It's bias evidence. It's also, I mean, that's the overarching theme, legal theme anyways, which is to say that encompasses inconsistent prior statements and also contradiction evidence. But it's all under the rubric of bias. And so I think that if you look at State versus Yang, U.S. versus Whitmore, this confirms that that is the avenue that we can take. But mainly it's the constitutional right. State versus Barreau, 2002, WIS App 198 is probably the best case on this in terms of bias and self-interest and impeaching credibility. So we're impeaching the credibility of Mr. Washington, and of course they have the opportunity to do the same with Mr. McAtee because he's in a similar situation. He's facing the exact same things that that Mr. Washington is in terms of federal penalties. They're in different cases, but they're facing the exact same mandatory minimums that you quite often face in these drug conspiracies in federal court. So, so that's the essential elements of what we're trying to present here, and I think it's well founded. There was things with Mr. Washington that were not covered on direct or cross because at the time we didn't know because we hadn't interviewed Mr. McAtee. And so now that we have, with the permission of his lawyer, and his lawyer should be here for his testimony because I've been in contact with him, there won't be a privilege problem. And you know, Mr. Gravely is also intending to potentially impeach him with some jail phone calls, which were produced to me yesterday. I reviewed those. I don't find much in there for impeachment, but in any event, I think one of the items that Mr. Gravely might have an objection to is some of the comments that Mr. McAtee made about the district attorney's office and Mr. Gravely in particular, and that is that that he, and you read the report, but that he polishes witnesses. That is, they have one story, they go in to meet with somebody from the district attorney's office, suddenly they have a different story and they get a good deal. So that, to me, is his perception, his lay opinion about how he perceives the district attorney's office, and so that may or may not be a bone of contention for the court, but I don't think it should be because it's his perception. And then finally, I think that Mr. McAtee can testify about not only these, well, they're not going to be inconsistent statements anymore because, and they're certainly not going to be hearsay because we're going to confront Mr. Washington with them first, which is why we're calling him first. I guess after our next witness, but in that order. So, I don't know what else, what other legal basis Mr. Gravely might have for excluding any of this, but I'll let him speak to it.
I didn't hear counsel say that he was going to ask to introduce any statements of Zachariah Anderson through McAtee. Was I correct that he does not intend to introduce?
I did not hear that.
What?
I didn't hear that.
You did
I did not hear him.
make an offer of that.
Right.
Right. Okay, because I believe those all to be hearsay, of course. Any statement from regarding McAtee, hearing any communication, anything that would be considered a hearsay statement from the state's perspective is simply inadmissible under the definition of hearsay 90801 and its exceptions. But counsel did not represent that, so at this point I believe he is precluding himself from asking those questions.
Well,
oh, I'm sorry. Have I interrupted?
I was just going to correct. Saying they're not hearsay because he's going to have a chance to confirm or deny them. Mr. Washington is, and so I'm going to ask him specifically what was attributed to him. He'll deny it, and then I'll ask Mr. McAtee.
No, I'm sorry, counsel.
No, he's talking about he's talking about a concern that you may attempt to introduce statements of the accused through Mr. McAtee. And you might want to know that Mr. O'Bear is behind you wagging his head no.
No.
So that appears to be the consensus.
I will always take guidance from Mr. O'Bear, but no, but it's more of an absence of statements. In other words, Mr. Washington says...
Here, no, what we're doing now is we're talking about something that isn't an issue right now, because while it's true he did not exclude that possibility, which is what you said, he also did not advance it. So I'm not going to touch it. It's not on the floor right now. If he tries to do that, we'll have to look at the rules and apply them.
Okay, well,
that. Generally under State against Johnson, as you well know, the defendant's statements are gauged by the same hearsay standards as anybody else's when offer on his own behalf. So we'll leave it at that.
Okay, so then in terms of the absence of statements, I just want the court to have this so that we don't have, I'm hoping to avoid our long pauses that the court has, been concerned about and that I think all parties are at this stage of the trial. So, I think this is a sincere effort from both sides to try to give the court our arguments ahead of time so that we do not end up in that situation each time. So I have quoted multiple times with a little bit of relish a case State v. Tabor, T-A-B-O-R, because of the wise circuit court judge who made decisions in that case. It is at 191 Wisconsin 2nd 492 Court of Appeals case, and it's a 94, I think 95 opinion. And the court, this is it's an analogous situation in terms of the absence of something. Right? Criminal conduct, those kind of things. So in that case, in Tabor, the court ruled that in a sexual assault case, you could not bring on additional people to say, well, he didn't commit a sexual assault against me, and I was similarly situated, those kind of things, right? And the court said that's irrelevant. On the basis of relevancy, you said the fact that a person has not done some injurious conduct to one person is not relevant to whether they have done it to another, even if there's a similarity of situation. The Court of Appeals agreed with the court. The Court of Appeals felt that the Honorable Judge Bruce Schrader was completely correct on that matter. And to me, this is an analogous situation, right? You could have 50, 100 people in the jail, all of whom could say, yeah, he never confessed to me, he never confessed to me. It's irrelevant. It's irrelevant for the reasons that you outlined in Tabor. That is my argument about the absence of something happening with people who have some similar situation. Judge, I think we have a moment of consensus in me indicating that I think that Marquand Washington, in light of this investigation, can be confronted. So I do not take issue with that, with whether he made these remarks to Mr. McAtee. If he denies that he made those remarks to Mr. McAtee, then I believe it would be admissible to have Mr. McAtee take the stand. Obviously, if he denied that, I apologize. I think I said admitted. At that point, I think I'm not disagreeing that anything Marquand Washington said regarding this issue can be asked of Marquand Washington, and then I think there's a hearsay exception that is appropriate. The one thing I do want to say is, if I read this investigative report correctly, he is prompted in what appears to be a decision based on his jail phone calls, which is a change of decision. He's prompted after hearing the testimony of Mr. Marquand Washington on the radio, and so I am concerned that that may be a vehicle that the court should at least pay attention to in terms of whether. So that is the only piece there. In terms of the reputation, and it doesn't say DA's office. Counsel said that he was talking about the DA's office, but according to the investigative report provided by defense counsel's the person in defense counsel's contract employee, he says the DA in this case is a master of polishing witnesses. This would be a pure speculation unless he's speaking about his own case. And he appears to have heard this from inmates, which would mean that, of course, his basis would be hearsay. He goes on to say that people who have had prior recanted or corrected witness statements then turn out in light most favorable to the state. And he goes on to conclude that this prosecutor that he is describing, he's heard about this mainly in domestic violence cases. And I think the court knows that in my last 15 years of employment, which would be during the time Mr. McAtee would have some basis of hearing rumors or gossip or statements from parties, that my assignment has not involved domestic violence, and so I don't know when I would have interviewed a domestic violence recanting witness in any case. Obviously, some homicides are domestic violence, but that would not involve a recanting witness because those individuals are deceased. So we would end up having to put on a witness, theoretically, who would describe what my duties have been over the last several years and who would describe whether I have handled any domestic violence cases.
Any deeper into this?
Yep.
I think you're presupposing I would be receptive to this opinion evidence from Mr.
McAtee.
McAtee anyway. Are you intending to offer that? Reputational evidence about the prosecutor?
Yeah, it's not necessarily reputational. Well, I guess it is. Yeah, but it would be opinion testimony rationally based on his perception, having spent a lot of time at the jail and seen people come and go, and so he doesn't need to get into specific instances. But yeah, so that would be part.
Maybe he's just a Republican.
And I mean, I'm aware of places in the statute where sometimes you're allowed to bring up reputational evidence of witnesses and other parties, but I'm not aware of one that...
That's for truth and veracity, not for...
Right, but I'm not aware of anything that says you can comment on prosecutors.
So...
or defense attorneys, just so we're trying to be as even-steven as we can.
Yeah, and so that raises one last issue here, which might actually make Mr. Gravely a witness. So... we, the defense team, excuse me, were contacted by a number of people and were sent clips of Marquand Washington's direct testimony. And in particular, and this was people watching Fox 6, et cetera, and of course I did not see this because I was up questioning him. But the clips were essentially, Judge, that you remember. I don't know if you remember the testimony about him describing Zach in his sleep, and he said, "quote die, 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 motherfucker," end quote.
I do.
So that exact testimony, where you had the court TV cameras initially pointing towards Mr. Washington. But then as he was saying those words, those very words, the camera panned to Mr. Gravely. And one can see Mr. Gravely mouthing the words, die, die, die. And so I had members of the court TV staff make a clip of that, so it's unaltered, directly from their feed, and I was going to confront Mr. Washington about that very subject, and also what, more in depth about what his conversations with Mr. Gravely was in terms of preparation, and whether or not that makes Mr. Gravely a witness, that's a question for the court. But I intend to mark that as an exhibit and show it to him, and question him about it.
That when they panned, I repeated the same thing he had just said?
No, you did it simultaneously. It was simultaneous, and it's very clear.
And so why would you have, why would either the video be evidence for the jury, and B, why would I permit Mr. Washington to comment on it unless you're suggesting that you said simultaneously?
Simultaneously.
Unless you're suggesting that Mr. Gravely has been feeding the witness answers.
That's exactly what it looks like. I mean, that's why people contacted us. It's exactly what it looks like. And, it's the same thing with, this whole business about Mr. Anderson supposedly putting his lips when his daughter's on the stand or whatever, signals to a witness. And so it seems fertile grounds for cross-examination of Mr. Washington. And if the court wants to review the clip that I'm talking about, I'm happy to provide it and mark it as an exhibit right now because it's compelling, and that's why people sent it to us. I wouldn't have seen it if people hadn't sent it to us.
We're 45 minutes late getting started, so finish up and then.
So the report provided by law enforcement regarding what was said by Marquand Washington includes that phrase. So this is not a phrase that was invented in the courtroom. It's not a phrase that is in any way something that the state provided to Mr. Washington in this court. And the Judge, I've been exposed to a number of outrageous charges in this case, and the court has patiently listened to those. There has been absolutely no feeding of any testimony to any witness. I have litigated for years and years and years and have no intention of jeopardizing my law license or my career by feeding an individual a witness on what is just a case that's going on in a criminal trial here. And this kind of accusation, and I understand that counsel got it from somebody on the internet, but this kind of accusation is poisonous to this proceeding. And I just want the court to know that I don't think it is an avenue that's an appropriate avenue of exploration in front of this jury. It essentially accuses this prosecutor, who they have had to listen to and have this go on throughout this case, and puts in the mind of a jury the suggestion that I have fed some evidence, and it is. And I want the court to see that clip before it ever made a decision that such a question could be asked of Mr. Washington.
I'm not going to pre-screen what questions might be asked and give approval or non-approval in advance. You'll know. If there's an objection, I'll rule on the objection.
But the taint is out there then, Judge, is my concern.
Well, I don't, if he claims that you were feeding answers, I can't tell him. You can't do that. He's entitled to make that accusation if he wants to. And if it turns out badly for his case, that's not, I don't know how I would preclude him from something that he claims. And I suppose if I have ultimately to make a rule on this subject, then I will look at this video. But that in and of itself is not going to be determinative. I will tell you, well, I'm not going to say that. Let's just Let's just begin.
Judge, if I could have the witness come in to take stand. We're starting with an officer before we get into the inmates. So it'll be a quick witness, so then we can get.
Well, where is the officer?
He's outside because we were discussing other witnesses' testimony.
Can I ask did the court sign a court order as we were required to do to get some sort of a clip of this interaction between myself and Mr. Washington?
I did not sign any order.
Okay.
I issued a subpoena to Law&Crime, and they provided it for me. And so, if there's some foundational question, I have somebody available.
Thanks.
Law and
Crime.
And Madam Court Reporter, this is going to be James Kendall.
Can I bring the jury in?
Yes.
Hello. Would you come down, please?
Yes.
Thank you. Okay, good afternoon, and let's continue with the defense. Would you raise your right hand, please? Do you solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Now, before you start, I did also, in a moment here, start to read the original complaint in the that you had supplied to me. And I remembered it immediately because at one point I think the case was assigned to me, so I'm familiar with it. And it would appear to meet the requirement of the prerequisites under 90608 of recency and nature of the conduct described to qualify as impeaching material. Just so you know, and it had nothing to do with this particular witness. So, go ahead.
Thank you. Good afternoon, Detective. Could you please state and spell your name?
Yes, James Kendall, Kendall.
And Detective Kendall, where are you currently employed?
City of Kenosha Police Department.
And for how long have you been employed with Kenosha Police Department?
This is my 28th year.
And in those 28 years, how many years have you been a detective?
Since 2005.
And are you currently assigned to any specific division or role, or is it just generally where you're needed, you'll go?
I'm a financial crimes detective.
And back in 2020, was that your assignment?
Yes, ma'am.
I'm going to jump to May of 2020. Do you remember being involved in an investigation regarding Rosalio Gutierrez?
Yes, I do.
And what was your role in that investigation?
On a specific date in May 2020, I was requested by the Detective Bureau Supervisor to follow a vehicle from one evidence storage location to another.
And do you remember the details about that, or would you need to see your report to refresh your recollection?
I remember.
Okay. And so do you remember the vehicle that you were watching being transported?
Yes, it was a 2004 white Ford Explorer four-door.
Okay. And could we pull up Steve?
Do you need it? Is there a picture of it? Okay.
That's fine.
What do you need?
State's Exhibit 1, I think it's. Okay, if you could just look on the screen, I've pulled up State's Exhibit 1, Photo 1. Do you see the vehicle you were just referring to in that photo?
Yes, ma'am, I do.
Could you just describe where it is for the jury?
It looks like it's in an apartment building complex in the parking lot.
Okay, it's that truck in between the squad car and the four-door vehicle?
Yes, ma'am.
Thank you, counsel. So you followed that truck and to, was it Jensen's tow yard or a different tow yard? Do you remember?
Jensen's tow yard.
Okay, and when you followed the truck and it arrived there, what did you do next as it relates to the vehicle?
I had the tow truck driver raise the vehicle. It was on a flatbed. Raise the vehicle.
And why did you ask the driver to do that?
Another request from Detective Bureau Supervision was that I would look for any GPS devices that might be attached to the vehicle.
And why did you want to look, well, strike that. Why did you want it raised to be able to complete that?
Just to be able to look at the undercarriage.
So did you do a complete examination of the undercarriage?
Well, I guess I would what you would define as a complete examination.
What type of examination did you do in your search pursuant to the other officer detective's request?
Look for anything that was obvious. It's a 2004 Ford vehicle that has Wisconsin winters underneath it. So it's pretty rusty. So I was just looking for anything that might be obvious that would stick out.
And did you find anything?
No, ma'am.
Did you also search any other areas of that vehicle?
The inside cabin, I recall that the vehicle had a bunch of tools in the rear of it, as well as in the interior. So it was just a couple of locations in the council that I looked for.
Did you remove any interior portions of the vehicle to search anywhere?
In my report, I refer to removing the consoles, but that was the glove compartment, just to see if there was anything that had been installed behind that, and then the fuse panel for the vehicle to see if there was anything installed there.
Did you find anything?
No, ma'am.
I have no further questions for this witness.
Detective Kendall, this was an activity that you conducted on May 20th, 2020?
Yes, sir.
So in the evening hours of May 17th, 2020, do you have any idea whether any kind of GPS device might have been mounted on that vehicle in any fashion? So
I'm going to object to speculation.
Well, the question itself inquires whether he has any idea. That in and itself is not speculation, but the next question would probably be loaded with it. So you can have that answer, though.
I'm sorry, can you repeat?
Sure. Well, I'm going to ask you a hypothetical question instead. If someone had removed a GPS device that they had placed on this vehicle 2 or 3 days earlier, let's say on the 17th of May?
Judge,
Was there- let
I'm
me
going
finish.
to, no, because at this,
My hypothetical, counsel, if I
Well,
could finish.
your hypothetical is argumentative.
Quiet. Finish your question.
Thank you. If someone had removed some GPS device that they had placed on this vehicle, say in the evening of May 17th, 2020, would you have seen any signs of that removal in the inspection you conducted on May 20th?
I'm going to object as it's argumentative in the form of a hypothetical question.
No, he's actually, it's somewhat argumentative, but it is specific information that he's seeking from the witness. The objections overruled.
It would be unlikely.
Okay. And so, based on your inspection, do you have any means to have knowledge of whether a GPS device was on this vehicle 3 days earlier?
No, sir.
Nothing else.
Nothing, Judge.
Mr. Counselor.
At this time, Your Honor, the defense will recall, Marquand Washington.
Continue to be.
From his prior testimony, Judge?
Yes.
Okay, thank you.
All right, this is... Can you see me okay, Mr. Washington?
Yes.
All right. It's kind of problematic here, but we'll do the best we can. Yeah. I'm just going to move over here a little bit. All right. Mr. Washington, you testified a few days ago. You remember that?
Correct.
Where Mr. Gravely asked you some questions and I asked you some questions, right?
Correct.
All right. So, but there's been some development, so I want to ask you some more. If you don't understand any of them, again, feel free to ask me to repeat them, okay?
Okay.
And if you want to take a break or confer with Mr. Gravely or with your lawyer, that's fine too, okay?
Okay.
So, I wanted to ask you a number of questions about, I just want to actually refresh your memory, first of all, about your time in the cell with Zach.
Okay.
So, if I remember correctly, you had, and I'll just summarize these, but you had said that he was sleepless and he and
Objection. This is all leading. So this is a recalled witness. I'm object leading.
well, Judge, first of all, this is originally the state's witness, so I would ask for some leeway to treat him as a hostile witness. I think that's fair.
Well, it is somewhat leading. It is strictly cross-examination, but up to this point, I think I'm going to overrule the objection. Go ahead.
Okay. So, but you've been in custody on this federal case, well, starting when? What's your recollection?
Since October 19th of 2021, I believe.
Okay. And during that time, there was a period of time when you were sent to segregation or the hole, right?
At what point in time were you asking about?
January, February timeframe of 2022, so early last year.
I believe I put myself in a hole when they moved me off of the unit by Zach and them, because they moved me to the dorms, and I didn't want to be in a dorm, so I placed myself in a hole, yes.
Okay, so you did that voluntarily?
Correct, to get moved back to the cells.
Okay. And so your nickname, is it Munch?
Correct.
And do you know an individual by the name of Maine?
Maine?
Maine.
No.
Do you know a Nicholas McAtee?
McAtee? No.
McAtee?
No.
Okay. So when you were in segregation in early 2022, well, first of all, can you just confirm that segregation is a situation where you're in a cell by yourself, right?
Correct.
And you're in your cells 24 hours a day, right?
Correct.
And you only get out to shower?
Correct.
And you can't see people in the other cells, right?
Correct.
But you can talk to them, right?
If you know somebody or want to yell through doors, yes, you can.
Okay. So while you were in there during this time frame, you were in on a federal case, right?
I am federal MAS.
Right. And in KCDC, there's that's one of the facilities that the federal government uses to hold federal prisoners, right?
Objection leading. Hold on. Hold on for just a minute. What the purpose of these facilities are is where it's a yes or no question. Leading.
What he knows, and again, this is.
I guess what I'm. Is there a dispute about the particular issue?
There isn't. I'm hoping we will get to something, as opposed to.
Your objection is overruled.
Thank you.
So that's a facility that's used by the federal government to house federal prisoners, right?
Yes.
Okay. And while you were in segregation, I'll call it, you would probably call it the hole, right?
Correct.
So while you were in segregation, there was another federal prisoner there that you were communicating with from your cell, right?
No.
Absolutely not.
Absolutely not.
Okay, so let me just make sure that is this the only time frame where you were in segregation?
Every time that my level has went up and I've been moved to the dorms, I would place myself back into the hole to get moved back to privacy. So probably 2 or 3 times.
2 or 3 times. And in those 2 or 3 times, you didn't meet an individual by the name of Maine?
No.
Also known as Nicholas McAtee?
Never.
And so you weren't talking about, like, you didn't have a conversation with him about, quote, jumping on other people's cases?
He's already testified he doesn't know the person. So by definition.
Well, I will say that when he was asked the question, he was asked about McAtee, and I believe that the answer was, I think you said McAtee?
But I was trying to pronounce whatever name he
Well,
said.
I understand, but
Correct.
So it's not entirely clear to me that he really understood who the information was desired about. So the objection's overruled.
Okay. You made a statement talking about how easy it is to, quote, jump on other people's cases, right?
No.
You made a statement that says, quote, you have to find a way to put yourself on someone's case to get time cut off your sentence, end quote.
Absolutely not.
You made a statement after someone inquired about how you do that. You said, quote, you have to get a person to talk and find out about their case and make yourself part of their case, right?
No. Wow.
You made a statement that says, quote, what if you, well, you were asked, what if you don't know anything about the case? You said, quote, then you lie about it. You said that, right?
No. What are the dates on this?
Well, you tell us. When did you say those?
I never said that.
Okay, well, then the dates don't matter, do they?
Objection. That's it. Hold on.
Okay,
That's
all right.
minute.
I withdraw. I withdraw that.
Stop it. From now on, you state your objection and you're done. All right? That was kind of an argumentative question.
It was. I withdrew it.
Okay.
So you also stated, when asked if you would lie about somebody's case, quote, absolutely, I do what I need to do. It's either them or me. I would just go and tell a detective that I know some information about a case. If I have to make it up, I would do it because it's either my life or their life, end quote.
That is a lie.
Okay. But you agree that in KCDC or any other jail, there's a lot of people, quote, jumping on cases. In other words, getting to know somebody and then calling up detectives to try and get time off of their sentence, right?
Objection.
I haven't seen it.
Just hold on. If there's an objection, you wait until I rule on it. Now, I didn't hear your objection.
I think it's irrelevant and would call for hearsay.
Overruled.
You can answer.
I haven't seen that done or talked to nobody who's done that. No.
Okay. Well, how much time in your adult life have you spent in jail?
I've been to prison twice before this, state prison.
Okay. For how long?
The first time I did maybe 4 years, I think, and then I got revocated after that for about 3 or so.
So during, like, before those prison stays, you spent time in county jails, right?
Yes.
And that's where, and so you're saying, like, how much time in county jails?
So,
just in round figures.
Again, objection, Judge. This is just irrelevant, and it's being used to try to attack the character of this particular defendant under a particular avenue.
Well, actually, if it were clear that it was being used just for that purpose, I wouldn't admit it, but my impression is it's being used for a different purpose. The objection is overruled.
So about how much time would you say you spent in county jails?
Months, maybe. I'm not sure.
Okay. So in your time in county jails, you've heard of people learning about a case and then calling their lawyer or calling a detective and saying, hey, I got information about, Mr. Jones's case.
Irrelevant if he's ever heard of it.
Rephrase your question.
Okay. You're familiar with the concept of somebody jumping on a case?
I'm familiar with informants.
Okay. Well, like jailhouse informants, right? Is that what you're referring to?
Like, if that's what you call it, I'm like, guess. But I know about informants, yes.
Well, I mean, there's informants that might be on the street, right?
They could be locked up as well.
Right. Like you.
Right.
For example, right?
I'm locked up, yes.
And you're an informant, right?
If that's what you labeled it as, I guess so.
Well, I'm not labeling it. What would you call yourself?
Objection, again, irrelevant what he would call himself.
Okay. So you have heard of the concept of people jumping on cases, right?
I'm not sure about the jumping on cases part, but I heard about informants getting whatever, being an informant and telling on people, yes.
Right. Like in jail, they would tell on maybe their cellmate or somebody they would see at meals or whatever that they had gotten to know, right?
Objection, irrelevant what other people do or what he's aware other people do. What?
The objections overruled.
You can answer.
What did you say again?
I said you're aware of these informants in jail, informing on or calling detectives or their lawyers about somebody else's cases, somebody that might have been their cellmate or somebody they know just from the general population, right?
I'm guessing people do it. If I've done it, you saying, that's what you're saying?
Yeah. So you're familiar with that concept, right?
I guess so.
And some of those people just flat out lie to try and help themselves, right?
Speculation, objection.
It would incorporate some speculation.
I'll rephrase. Those people that are doing it are out to help themselves, right?
Objection, again, speculation.
The objection's overruled.
I'm not sure what other people do things for.
So, when you were preparing to give your testimony last week, there was some preparation involved, I would imagine.
What do you mean?
I mean, you met with Mr. Gravely, or you met with other police or other members of the prosecution team?
I met with them and told them about my statement and stuff before that.
Okay, I don't mean... I don't mean your original conversation with them about the statement you gave on January 18th of 2023. Was that the first time you had met with them?
In January, yes.
And so when you sat down with Mr. Gravely and the other people that were present that we already talked about, was that the only meeting you had with them?
No, I think I seen them before, another time after that before court.
Like one other time, two other times?
I believe it was once.
One other time? And where was that?
I don't know if it's this building or where it was at, but here in KCJ or whatever it is, I don't know. I don't know the name of the building. I'm not familiar with it.
Well, was it in the jail?
It was here.
It was in this building or in their office?
I think it was their office.
Okay. And so how long was that meeting?
Not long as the first meeting.
What, that was their, okay, no, all right. That was the meeting where you first gave a statement?
No, this time when I met with them and I seen them, that was the second time I had seen them.
Okay, because I thought you just said it was the first, but okay. So now we're clear, that was the second time. And it was just those two times?
That I'm aware of, yes.
Okay. You think there might have been another time you weren't aware of?
No.
Okay, so just those two?
Correct.
All right. So, and so in that second meeting, that was to prepare you for your testimony that you gave last week, right?
If that's what you call it, I guess. I don't know.
Well, that was the topic of the discussion, wasn't it?
It was, yes, to let me know everything that I had told them that they had went over it and stuff like that, correct.
So they went over with you what, sort of reviewed what you had already told them?
Pretty much, yes.
All the stuff about Zach's sleeping habits, right?
They just repeated what I had said to them, yes.
So they were repeating stuff to you from the reports they written from your first meeting?
Yeah, they read what I had said and let me know that they had made a statement about it, yes.
Did they show you that statement?
I didn't get to read it or no.
Okay, so they just told you what you had said?
Correct.
Okay. And was it Mr. Gravely was doing that?
Yes.
Okay. And was anybody else talking, or was it mainly him?
Mr. Gravely.
Okay. And
Can I
so,
hear you, sir?
Mr. Gravely.
so he told you, this is what you said before, this is what you said before, this is, just went right down the line, right?
Pretty much, yes.
Okay. And was this the point where he was saying, well, if you stick to this, I'm gonna look out for you, and I'm gonna go to bat for you with the federals?
He never said that.
Okay. So, but that was your understanding, right?
What do you mean?
That was your understanding that if you said the things that he was saying in that meeting, if you said them on the stand, then he would go to bat for you. That was your understanding.
If you look at it, I guess so, yeah.
Okay. So when you actually testified, when you were in that seat last Thursday, I believe it was, you had made a comment about Zach saying, quote, die, 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 motherfucker. Do you remember that?
Correct.
And while you were speaking those words, you were looking directly at Mr. Gravely, weren't you?
I'm not sure who I was looking at the time.
Okay.
He asked me, I think he had asked me the question, so I may have been looking at him, but I'm not sure.
Okay. And as you were mouthing those words, he was mouthing them back at you, wasn't he?
I can't say I recall that. I don't remember that.
Okay. One moment, Judge. So you don't have a recollection of that?
Correct.
Would it refresh your recollection if I played you a clip from Court TV showing that very moment?
Objection, Judge. From the state's perspective, this is if this is something that's going to be shown in any fashion, it's not been disclosed.
Well, the
previously.
question was whether it would refresh his recollection, which would ordinarily not be, just be for the witness to observe.
Well,
whether it would refresh his recollection.
In the context of asking, they explained what it was. I assume the purpose of that was to let the jury know what the item was. So I would object to the phrasing of it. And again, we've had no notice of this. This is not an item that's ever been disclosed.
Well, I hate to do this. Please don't talk about the case during the break. All right. I think the district attorney's point is has some validity, that it wasn't necessary to get into what the source was. But, I mean, what else would it be? The witness is fully aware. There's a camera trained on him all the time, so obviously it's court TV. But the question actually is, would it refresh his recollection, which would ordinarily not be something that would be seen by the jury anyway. And I didn't know whether there had been an answer or not from the witness. Quiet. Huh? No answer. So he hasn't answered. As far as there being no notice, I mean, how much notice can you have had? It just has come up.
Has it just come up?
Well,
they haven't told us that. They have taken the time to do a subpoena.
Well, when would they have gotten the video?
Well, this was last Thursday, Judge. We are now, that is 8 days ago.
Right.
So if this occurred last Thursday, counsel has not provided you any information about when that subpoena was done or what this is. We have a right to have notice of things that would ever be utilized as an exhibit or actually used for demonstrative purposes in court.
Well, we're not that point.
Well, okay.
Just for the record.
Refresh his recollection.
For the record, the subpoena was yesterday, so I can.
Well, probably he would answer the question. I'm just proposing to add.
Well, the question is, if you saw a video of what he claims occurred, would that refresh your recollection on the question previous? Does that make any sense?
I'm not sure how it would refresh. I don't remember.
I said it's not. He doesn't know if it would refresh it or not.
So let's try, because it might.
He ended his remark by saying, "I don't remember." He's already said, "I didn't see that." So how do you refresh? Counsel, just for a second. How do you refresh someone's memory when they have said, "I didn't see that and I don't remember"?
Well, actually, the law on refreshment of recollection is that anything can refresh your recollection, whether the witness is familiar with it or not. I don't see the harm. I am going to look on too, while he looks on it, and in case we get further into this.
Just so that the record is clear, I've just now been handed a copy of this. Rather than being handed a copy at some prior time, I've just at this moment been handed a copy of this item. Thank you.
It was subpoenaed yesterday? Yep. And when did you get it?
Somebody from our team got it. I don't know. I just became aware of it. I don't know what day it is. Earlier this week, and then by the time I acted on it, so.
Well,
we weren't sure who the witnesses were going to be or what. So.
Well, we'll see. Let's take one thing at a time. The current inquiry is he doesn't know whether it would help him or not. So I'm going to let him look at it, and there's a separate issue in the event that the state desires to offer it.
What's the date today?
The 17th.
Switch around to
offer it.
I beg pardon?
The state desires to offer it in case the
Did I say state? Yeah. Oh, Kevin, you're here. If in case the defense desires, well, if anybody wants to offer it. But all right, you can show it to him. And let's set it up so I can see too.
Did you want me to put it up here?
Yeah, if you know how.
I think so. I'm going to need a adapter.
Watching it now. There's sound.
So,
Yep.
so I'm not sure if I have to have my sound on for this. You know how to get the sound? I don't know if we can get it louder.
What do you remember about that?
I remember I was laying there. I told him about the next day that I was laying there, and I moved my foot, and I heard him shouting before he woke me up.
What did he shout when you heard?
He said, "Die, die, die, motherfucker."
So it's a little.
And so, did you ever have a discussion with the defendant about this nightmare that you heard?
So that's not a perfect representation, given that there's some lag.
Well, the pending question is
Does it refresh his
whether
recollection?
it refreshes his recollection.
Right, correct. So do you remember, as you were speaking those words, Mr. Gravely mouthing them towards you?
It seemed like as I said it, he got to repeating it, but it didn't seem like he said it first or repeated it to me or something, if that's what you're asking.
I'm asking if it looked like he was mouthing them towards you as you said them.
Right there,
No, I'm saying from your memory, not from what you just saw.
Oh, from what I remember,
Yeah.
I didn't remember that, but
Okay. All right.
Can the jurors come back in now?
Yes.
All right, yeah. Okay, go ahead, Mr.
Thank you. So to answer the question is you don't recall that happening while you were testifying last week?
Correct.
That's all I have, Judge.
Mr. Washington, you believe we've spoken twice?
I believe so.
First time was over in the facility with several officers present?
Correct.
Took a little more than an hour?
I believe so, yes.
And you outlined what you had heard from Zachariah Anderson in as much detail as you could provide to the several people who were present?
Objection. Correct. He's couching, he's flavoring the answer for the witness.
I'm allowed to lead.
It is cross-examination.
Is that the case?
Correct.
Okay. And the second time we met, it was it appeared to you that the purpose was to prepare you for the trial?
I believe so.
Okay. Did you understand the trial was already going on?
Yes.
Did we spend around a half hour together?
Give or take.
Okay. And did I ask you whether did you and I go through the items that you had previously told myself and law enforcement at that previous meeting in January?
Yes.
And were there multiple people present for that meeting as well?
Yes.
Okay. And during that time period, the second meeting, did I ever use any phrase like that I would go to bat for you? Did I ever say anything, any even approaching that?
No.
In fact, you are a person who has a federal prosecutor involved in your case, correct?
Correct.
Are you aware of any ability I would have to directly impact your case?
No.
Is it your understanding that the way this would work is if you are honest in your testimony that your attorney would let the federal prosecutor know and they would make a decision on your case?
Correct.
Do you think that I am in any way a decision maker on what happens next in your case?
No.
Now, you were asked if something refreshed your memory, correct?
Correct.
Okay. And what was your perception of what you saw?
Sound like you was repeating what you already knew I was pretty much finna say after I had started saying it.
So you were saying something, and I was saying those words after I heard you?
Correct.
Now, you were asked several questions about, time you've been in prison and in the jail. Have you ever been a person who informed on individuals previous to this time?
No.
And have you informed on anyone else in this federal prosecution case other than Mr. Anderson?
I object. What's the possible relevance of this? This is exactly what he was seeking to keep out.
And was, go ahead.
Shame on me for not interrupting sooner. Rephrase your question.
You testified in Racine on a case you were an eyewitness to, correct?
Correct.
And other than that, have you provided any information to law enforcement about any other cases?
No.
No?
No.
Were you housed with individuals charged with first-degree homicide named Renan Brownlee? Was he somebody you were housed with at some time?
Yes.
Did you ever inform on him?
No.
Objection. Same objection, Judge.
That's,
How is this possibly relevant?
Sustained.
Well,
State versus Tabor.
let's talk about the security dorm for a second, okay?
Yes.
is that, if you know, is that called HW?
You talking about the hole?
Yep.
I believe so, yes.
Okay.
Hollywood.
And can you describe how that is put together? Like, are the cells like circular where they all face each other? Or are there multiple levels? What do you remember about it?
It's kind of like cells that's covered up with little bitty holes in them that you could barely see through because you can't really see through them. And there's an upstairs and a downstairs where we can't really see who we talking to or really talk to nobody. And the cell that I was in was far to the back under the stairs.
Okay, so if I told you you were in 09, does that sound familiar?
I believe so.
And is that in the first floor?
That's the first floor, correct?
Okay, there's a second tier as well?
Correct.
Can you, you were on the far end?
Correct.
Do you know where cell or bed 20 is?
I believe that's way on the other end.
Okay, and is it upstairs or downstairs, if you know?
I think it's upstairs.
Okay, so is it your memory of the whole that somebody on the first floor in 9 would be able in any real way to communicate with somebody who was in the second floor in 20?
He would be yelling and talking to everybody, so I can't see no person really doing that.
And if I indicated to you you were in the hole from March 2nd to March 22 to March 5th, 22. I'm sorry, I apologize. February 2nd, 22 to February 5th, 22 in bed 9. Does that sound familiar?
Yes.
Okay. And while you were in during that period of time, from February 2nd, 22 to February 5th, 22, were there any other inmates in the hole during that period of time?
I believe there was, but I didn't know nobody.
Have you ever been in the hole where only one or maybe 2 beds were the only ones taken, or is it always occupied with more people in your belief?
Every time that I went, it was always occupied.
By
multiple different individuals.
Now, Mr. Washington, do you perceive there being a physical danger in being a person who would be a federal inmate who would become known as a person who had jumped cases or informed on people?
Yes, I do.
Okay. Would you ever be a person who would yell out loud
No.
in a jail? Well, let me finish. In a jail setting, recommendations or details about how to be an informant?
No.
Why not?
Because that's not something you want to be in here and for everybody to know that you're an informant. So let's just put it out there for everybody to know. Because you could be all type of, you could be beat up, you could be ridiculed, you could be everything. It's not safe to do nothing like that, and I wouldn't do nothing like that.
Can I go quick sidebar?
afternoon break. 10 to 15 minutes. Please don't talk about the case during the break. Read, watch, or listen to any account. Now, I let's play the video again.
While he's setting that up, I wanted to indicate to the court that the defense counsel specifically represented when the court asked the question that they had done a subpoena yesterday for this item. We have now been provided a copy, and it indicates that it was modified, meaning that this item was manipulated on March 15th, which would be 2 days ago at 10:14 a.m. So the idea that a subpoena was done yesterday, from the perspective of the electronics we've been given, appears to be demonstrably false.
I received the clip yesterday, and if I said the subpoena itself had to be the day before, because I had to prepare it.
So
I want to, well, go ahead, finish.
Well, I just want to express to the court that the court asked that specific question when I complained about lack of notice, and counsel chose to make a representation to this court about this item, which is a surprise, and in which they sought a subpoena without any knowledge of either, certainly without the state, and it doesn't appear the court was directly involved. So to have misrepresented something so clear and fundamental from the state's perspective is something the court should take stock on in this case. You know, and this is not the first time we've had episodes where there have been specific representations made which were then demonstrably able to be proven false. And so here we are again. And so I just want to be sure the court is taking that into account when it thinks about presentation of this evidence in any fashion.
So if I made a mistake about a date, then that's one small error. But what's clear is Mr. Gravely always raises this after he's on the hot seat.
You know, why don't you just tell me what you want to see without commenting on Mr. Gravely?
So I think there's also no sound. Will help? This is on the Mac side.
So I just want to let the court know why I believe there's a lag that is clear. I believe that that Mr. Washington says, die, 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 motherfucker. Apologize for the language. That you can see me say die 2 times, which implies, from the state's perspective, clearly that I am behind and repeating what is something that is being said to me and to everyone in the courtroom.
There's a delay on the backside.
I don't know what to tell you. You might want to.
This machine that I just show it to the court. I can't seem to play it.
Play it. Can you play it on the screen and take the audio off directly off the computer?
So.
I don't know. If you can't, you can't.
Let me try here. Oh, now we got it. All right.
Yes.
And what do you remember about that incident?
I remember I was laying there the night before. I told him about the next day, but I was laying there and I was reading my book and I heard him shout in his sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting as best you remember?
Yes.
All right.
Judge, from what you would see on this screen, whatever it has to do with this feed.
Take it back about 2 minutes, 3 minutes.
Well, the whole thing's only 38 seconds, but I'll just take it to the beginning.
What did Napoleon say? Don't ask me for time. That's the one thing I can't give you.
It appeared to you he was having a nightmare.
Yes.
And what do you remember about that incident?
I remember I was laying there the night before. I told him about the next day, but I was laying there and I was reading my book and I heard him shout in his sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting as best you remember?
All right, I don't know what the exact timing is, but on the video, as I'm seeing it, it appears that Mr. Gravely, his lips are moving shortly after the witness testifies.
It does appear that way there,
Okay?
but not on the actual item.
Not on the what?
Not on the actual item. If you were just to plug it into your computer, it would not appear that way.
It's very much simultaneous.
Yeah, the sound is coming out a little bit.
Well, give it to the district attorney to view.
I did. His copy.
We believe we've reviewed our copy. We hear the defendant, I'm sorry, Mr. Washington say "die, die, die," and I repeat "die" 2 times, which is
That's what I saw.
yeah. So I don't know what how I can simultaneously be mouthing the words
He
when I'm not
claims-
saying the same.
He claims that it shows up differently.
But just read my lips.
Pardon me?
But just read my lips. I only do it twice.
No new taxes.
I'm
sorry, what?
No new taxes. It's a famous line from President Bush the Elder. Well, I'm not supposed to put those into state equipment or. But I have a personal computer here, and I'm going to take a chance with it. Well, the record will reflect that I'm going to break the tape. I actually cut the tape, and there's a.
How can one coach a witness by saying something simultaneously with a witness?
Well, he says it's not simultaneous.
Oh, the representation is that I've said it first?
No.
Well, so what, would we have rehearsed some
I don't want to talk about it right now. I want to look at it. Now where did it go?
How would you coach a witness?
I remember I was laying there the night before. I told him about the next day, but I was laying there and I was reading my book and I heard him shout in his sleep before he woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting as best you remember?
Yes.
All right. And so, what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And what did he shout that you heard?
He said, "Die, die, die, motherfucker." The fuck?
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting as best you remember?
Yes.
All right. And so, did you ever have a discussion with the defendant about this?
He woke himself up.
And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
Okay.
And you're quoting as
To
best
me,
you remember? Yes. All right. And so,
it appears that Mr. Gravely said, "Die, die, die," and also that he did so simultaneously with the witness. That's my impression.
That was our exact assertion, Judge, and therefore that was the basis of my question, which I wouldn't have asked if the state hadn't followed up on it. But
in our copy, we only see me say "died" twice, so I don't know if the court has a different copy or how that is working.
they're the same. You're right. He only says it twice on camera.
What did he shout that you heard?
He said, "Die, die, die, motherfucker."
And you're quoting. And what did he shout that you heard?
He said, "Die, die, die, motherfucker."
Well, now that I look at it again, the camera actually takes you out of the picture at the point where I say I saw the third one. So
He said, "Die, die, die, motherfucker."
maybe it doesn't show it 3 times.
No, it shows it twice. Yeah.
Yeah.
Did you ever have a discussion with the defendant about this nightmare that you heard him have, or these words he said?
Yes, I did.
Okay. I'm going to I'm going to keep this. You can get a copy from the district attorney, okay? And this is all one exhibit. Well, I guess it's already marked, so.
And I would move for its admission, just so it's part of the record.
It's received for record purposes.
Okay.
All right. So what's next?
Well, my next question will be, well, I don't want to preview it for the witness, but it'll be about this subject.
Okay. Did you ask the jurors to come in? Oh, I guess they're upstairs, huh?
Hello.
Would you come down, please?
Not a problem.
Judge says fair game.
Did you ask the jurors to come in? Oh, no.
The fireworks are not done.
Now we're getting commentary on the case.
I'm surprised they haven't asked for the DA to leave the room.
All right. Go ahead, Mr. Rosalio.
Thank you, Judge. So, Mr. Washington, when we broke, I think we were talking about the statement you made about your time with Zach and what he said in his sleep?
Correct.
So isn't it true that when you testified on direct, you were taking direct cues in your testimony from Mr. Gravely as he sat here at counsel table?
No, I don't believe so.
He was mouthing the words at you, wasn't he?
After I said it, he did say it. He repeated
He was
it.
mouthing the words at you?
Yes, he said it after I said it.
And that's where you took your cue?
No.
Okay. That's all I have at this time for this witness. Thank you.
Mr. Gravely.
We talked originally in January. Who brought up this idea that in a nightmare that the defendant had said, "Die, die, die, motherfucker"?
I told you about it.
And so when you testified on direct when I was asking you questions, did you have an independent memory of that being what Zach Anderson, the defendant, told you or said in the nightmare that you heard?
Yes.
And did you get any assistance from me in either remembering that or testifying about that at all?
No.
Nothing else?
I have nothing, Judge.
You may step down, sir. Go ahead.
Defense would call Nicholas Bakati. Actually, I would like to have one moment before that, before we bring him out, if that would be okay.
I mean, for you
Yep.
to talk to him, you go ahead.
I'm going to object. Why do we need a moment? This is not his attorney. This is his witness. My objection is let's keep going.
Well, I agree with about half of what you said. But as I told the jury, I think it was just yesterday, that it's customary for the attorneys to speak with the witnesses for a moment in an ethical manner, and I'm not going to deny him that opportunity.
It'll literally be 1 minute.
I beg your pardon?
Well, I'm going to ask we take a break if that's happening, just a short
We
one.
just took a break.
Well, I know, but
If you want to leave for a moment, you're welcome to do so,
thank you.
but come right back.
Thank you.
I beg your pardon?
This is the last witness for the day.
Oh, it is?
Yeah, just because that's what I know before.
Well, there is a transport issue with the officers. I suppose because this will take hopefully less than 10 minutes, another short break. Please don't talk about the case. That's all right. Chance, give me my cord, yeah. Okay. Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Okay, thank you.
Would you state your full name and spell your first and last names for the record, please?
My name is Nicholas Ryan McAtee, Nicholas McAtee.
Mr. McAtee, you appear to be in custody.
Yes, I am.
And I'm going to Judge.
Go ahead.
6. Can you tell me what that is, sir?
So I'm going to object to this exhibit, Judge. Why this individual is in custody is irrelevant because there's no cooperation agreement, so this is not relevant. I don't have any difficulty with being discussed in custody, but it's irrelevant.
My immediate reaction is it doesn't appear relevant.
Okay. I thought the state would be inquiring about it, but if they aren't, then that's fine.
Well, perhaps they will. I don't know.
Okay. Mr. McAtee.
Yes.
So you are in custody at the, well, tell us where you're in custody.
I'm in custody at the Kenosha County Detention Center.
Okay. And do you have a state case?
No.
You have a federal case?
Yes, I do.
And just, you don't have to get into all the details, but what's the nature of the charge?
Same objection. Why he's in
What the objection sustained?
Okay. So you are here as a witness for the defense, right?
Yes.
And had you been, for your testimony, had you been promised any benefits for that testimony by anybody?
Yes.
Who?
The prosecution.
Well,
And
objection. Irrelevant hearsay that we.
You say the prosecution meaning the U.S. government?
No. The state.
The state?
Yes.
Mr. Amit, to your knowledge, is there any kind of an agreement of any kind? No. At any level, state or federal? There is no agreement. Okay.
There's no completed agreement. There was discussions.
Well, so the answer, if there is an agreement, there isn't as of this point. Is that what I'm hearing?
That's correct.
Yeah, there's not.
You think
been
the
any
facts are
agreement.
otherwise?
No. There's not an agreement of any kind.
Okay. Any dispute as to that being the fact?
As of we sit here today, yes. Historically, that's not the case.
Now, don't testify.
Okay, but
Don't
yes.
testify. No. You can ask a question.
I will.
I know you won't disappoint.
Thanks for the confidence. Mr. McAtee, the court just spoke with your counsel, Mr. Ahmad. Is that right?
Yes.
So he's here in the courtroom. So as I ask you questions, or as Mr. Gravely asks you questions, if there's a time that you feel that you want to confer with him, feel free to ask, okay?
Yes.
Now, have you had time to talk to Mr. Ahmad about your testimony here today?
Yes, I have.
And do you feel like you've covered everything in terms of how this relates to your current legal situation?
Yes.
And do you have any questions for him at this moment in time?
No, I do not.
So getting back to what we were talking about before in terms of there's no agreement right now, but at some point there was some sort of offer?
Objection. This is irrelevant, and there is absolutely no way that there's relevance in this situation, Judge. Calls for hearsay.
I don't agree with you. The objection's overruled.
Was there a point where your understanding, without saying who said what, but your understanding about whether or not there potentially would be a situation where you would testify for the prosecution?
Yes.
And what was your understanding?
My understanding was that.
Sorry, sir, I apologize.
I'm sorry, but could he finish his answer? Wait.
He wants to make an objection, I assume.
Yep. Objection. It sounds like it calls for what his attorney has informed him, since I'm not aware of any other basis, and that would be hearsay and would be an improper area
Do you
to
want his
explore.
attorney to testify?
Well, I would suggest to the court that Mr. McAtee is not the person who should be able to report that, because it is hearsay and is not appropriate for him to talk about that.
Well, then Mr. Gravely is going to be a witness because.
No, please.
Well, no, because.
Please. It's not hearsay because it's not being offered, I assume. Well, it is hearsay, but I think it's an exception under the, what is it, subsection 4, plan, intent, plan. Let's take a look at the statute. Sub
90801?
3, 908.03 sub 3 are not excluded by the hearsay rule. Sub 3, a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition such as intent, plan, motive, design, mental, feeling, pain, and bodily health. So the question is really inquiring into whether he's been asked about whether there had been a deal discussed. And of course, he would gain awareness of that through his attorney, but it's not being offered to prove that there was a deal, but rather what his intent was. So the objection is overruled.
You can answer, if you remember the question.
Yes, I was offered consideration on my federal case for testifying for the prosecution, if I were to.
Did you consider it?
Yes, I did. Very seriously.
So I'm going to back up and come back to this. There was a time when you were housed with Zachariah Anderson, right?
Yes.
Do you remember when you were, was there more than one occasion when you two were cellmates?
Yes, on 2 different occasions.
So when, do you remember when the first one started?
Yes, it was in August of 2021 to roughly October of 2021.
Okay, August to October 2021?
Yes.
And so when you're, was this in just general population?
Yes.
So when you're in general population, how much of your time is spent together? Some regulation about that?
Lockdown in the cell is roughly 12 to 14 hours on a general population dorm.
And so, needless to say, you spend a lot of time together?
Yes.
So, did you get along with him?
For the most part, yes.
Did you, was he forthcoming about his cases or his case?
Objection, State v. Tabor.
I don't know how that applies here.
I'm not sure it does either, but I do think the objection is well stated.
Okay.
This is irrelevant based on State v. Tabor.
So
I'm not sure I agree with the case you're citing, but I do agree with your legal principle.
Thank you.
So, so you got to know him though over that time period?
Yes.
And can you tell us what you observed about his sleeping habits?
He slept roughly maybe 4 hours a night, 5 hours a night. Not anything abnormal.
Was there ever a time when he would have nightmares or wake up screaming?
Objection, same thing. Irrelevant based on case law.
Well, and I guess I do follow his rationale now. It's a Tabor-type incident.
There's case law right up.
Pardon me?
There is case law right on point on this issue.
Well, why don't you give me the citation?
Okay.
You bring it up as well.
The number of cases that deal with
Give me the most recent.
okay.
But are we making legal argument too, or are you just being asked to
Nope.
say the case?
For the case citation.
Just asking for the case. There is, the most recent is a 2019 case. It is unpublished, but the facts are so remarkably similar that I'll give it to the court at least for support. At State versus Yost, Y-O-S-T, 2019, Wisconsin Appeal, APP, 58. Again, that's from 2019. And that talks about inmates.
I thought we weren't going to argue about
I'm not
the case.
arguing,
We were
I'm
just going to
pointing
cite it.
Just give me the cite.
Gotcha.
Page number?
Paragraph 11.
Y-O-S-T?
Paragraph 11.
Counsel?
Yeah, Y-O-S-T.
Well, I actually am searching by,
Oh, I'm sorry. It says 2019 WIS app 58.
58?
Yes.
At what paragraph?
11.
Thank you.
Is it unpublished?
I came up with a published case.
Yes.
It is published?
No, the one I'm talking about right now, and I only pointed out because the facts are so similar. There's reference to a general rule in, as you see in that paragraph, Osseth versus Farmers Mutual Insurance, going back to 1959, talking about the general rule, as you can see, is that when the absence of a statement.
No, stop.
Okay.
Stop.
Gotcha. I'm not trying to argue. I'm just. Yeah.
Actually, I'm not finding the case.
Where did I see?
Actually, I did find a nice article about medicine.
I might have had that wrong.
But it is, it does seem to fit the pattern of cases that Tabor.
I think the assertion, Judge, in Yost and other cases is that, and that just was one we cited because it was so particularly on point, which is that the absence of a statement assertion is not a statement made to prove the truth of the matter asserted. So this is contradiction evidence.
No, stop. I'm going to try again.
My objection is not a hearsay objection. I apologize. Counsels, I think that I've made a hearsay objection. I have not. State v. Tabor is about whether this is relevant evidence, Judge. The court ruled in Tabor that this is irrelevant, and there's a whole line of cases that talk about that.
Well,
we're not talking about the hearsay
but in Tabor it dealt with, the victim versus the defendant. This is two witnesses, and so it's completely in opposite to Tabor's holding.
We couldn't find it either.
No, I have it. I just
Not
paragraph
the
58.
paragraph.
No,
Yeah.
it doesn't exist.
Right. I did.
The objection is sustained. Because, all right, the objection is sustained.
Anything that can happen has happened in this case.
Sorry, I'll state for the record that for once I agree with Mr. Gravely.
Well, then I object.
Yeah.
No, I'm objecting.
All right.
So, Mr. Mack.
I'm sorry. I've been surprised the jury hasn't made a run for us, Judge, much less people in the audience. But okay.
Mr. McAtee, I believe you said your first time frame was with, with Mr. Anderson was August 21, well, August of 21 till to October of 21,
Yes.
right? And then what was the, I mean, do people just get moved around a lot? Is that why some of this happens?
Yes.
Okay, so what was the second time frame, if you remember?
Second time frame was the
With Mr. Anderson.
beginning of February 2022 until beginning of July or end of June of the same year, 2022.
Okay. And and so when you spent time together, was there discussion about his case?
Objection. Again, it's the same objection, Tabor. So I have an ongoing objection to the point that the court will allow that, indicating that any statements made by the defendant to him.
Well, I wasn't asking for the contents of the statements or anything else.
Was there discussion about the case, which sometimes can be loaded with hearsay, but I don't think in this instance it sounds like it, so you can have this question, but...
Okay. Was there questions, was there discussions with him about his case?
Yes, there was.
Okay. Did you feel like you knew a lot about the case?
Yes, I did.
Same objection.
Okay. So
the answer can stand. Go ahead.
all right. So I want to go back in time now to a time when you were in segregation. You call it the hole, right?
Yes.
Do you remember when that was?
Yes, it was January and February to the very beginning of February, most of January of 2022.
And now, can you tell us what the hole looks like just physically when you're in there?
Like a rectangular room, cells that have plexiglass fronts. They're extremely dirty, so you really can't see what's going on. It's
the plexiglass is dirty.
Yeah.
Okay.
But it's very loud. All you can do in there is really talk to one another. There's nothing else as far as books or anything to entertain yourself with.
Okay. And so, how long in a given day are you in your cells?
23 hours.
Okay. When you're in that situation, excuse me, physically, I couldn't tell. Is there just one level? Is there multiple levels? How does it work?
It's 2 floors.
Okay. Are they just in a line, or is it some sort of rotunda?
It's more like a rotunda, yes.
Okay. Did there come a time when you found that there was another federal inmate in the hole at the same time as you?
Yes, I did.
And who was that?
His name was Marquand Washington.
What did he go by? What was his name, street name?
Called him Munch.
So when you were housed in the segregation unit, where was he in relation to you?
I was upstairs in the far corner in cell 22. He was directly across me, also upstairs, but in the opposite corner.
Okay. And were you able to communicate with him?
Yes.
And how is that possible?
Well, the noise carries in there, so it's if you talk at a whisper, you can hear it across the dorm.
And were you talking to him because you knew him before, or because he had a federal case, or what?
I had ran into him before in there, but only briefly. We didn't really know each other. We really just started talking because we both had federal cases, and there's not many people in KCDC with federal cases.
So did there come a time when the discussion between you two turned to him talking about jumping on other people's cases?
Yes.
What did he say when that subject came up?
Essentially, he was giving me advice, because one of the things that we talked about with our federal case is that we're facing so much time. And one of the ways he said that if you want to get out of your case, the easy thing to do is to just jump on someone else's case. And I had heard the term before, but he clarified and told me more about how to go about doing that.
And did you ask him about, like, to explain that more to you? About how he did it, or what his thinking process?
I didn't ask him. He was volunteering his method, I guess you could call it. And he told me what he did. And, you know, he found out information about people's cases, and whether it was going through their discovery or just asking them or seeing stuff in the news or newspaper, and using that to put himself into it by informing detectives that he had information.
And did he say what he would do if he didn't know something about the case?
He would make something up. He said, as far as he was concerned, it was his life or someone else's, and he said, you know, he would do that to save himself.
So, returning to the topic of you, there was some potential mention of you testifying for the prosecution.
Yes.
I mean, you knew something about Zach's case by talking to him, right?
Yes, and the newspapers and news.
Okay. Was that tempting for you?
Yes, it was.
What are you facing in federal prison?
Objection. That's irrelevant.
It's kind of relevant now.
What?
It's relevant now. Answer.
I'm facing a 10-year mandatory minimum to a maximum of life in prison.
And so the only way out of the mandatory minimum is to do what?
To inform or cooperate with the government.
What's your understanding as to what that takes?
It doesn't take much.
Have you heard the term substantial assistance?
Yes, I have.
What's your understanding about who has to make a motion for substantial assistance?
Objection. It's irrelevant. None of this is happening.
In this case, the state prosecutor, the district attorney.
Well, you have a federal case though, right?
Yes.
And so if you were to testify in a state case, the actual motion would come from the federal government, right?
Objection. That's leading.
It is leading.
Hold on. He's just indicated.
He agreed with you.
I agree with them. I didn't know how else to get there.
You're affirmed.
But it's your perception that if you come to testify for the prosecution in a state case, that it's the district attorney that would have to make the motion.
That's leading as well.
Motion?
Or make some sort of assertion.
It's again a leading question. He's just repeated the question.
I can rephrase.
Go ahead.
So, what is your understanding about, like, which level of government would need to act on your behalf in order to get under the mandatory minimums?
He's asked. That's been asked and answered. He's already said that the state prosecutor files a motion.
Well, is that really true?
No.
No.
I don't.
No, it's not. But that's what he's offered the court.
For some. Yeah,
No, he's. That's his. He has a false understanding.
I myself don't know the answer, but it would be my impression that the United States Attorney would file the motion on the representations made
That's
by
correct.
the local district attorney.
That's correct.
That's not what you asked.
I was trying not to be leading as much as possible. So I can certainly ask that question as a leading question.
Go ahead.
Okay. So it's actually the United States Attorney's Office that files the motion based on its discussions with the district attorney in the case you testified, right?
Yes, it is.
Okay. And you decided to forego that and testify on behalf of the defense.
Yes.
What benefits would the defense, testifying for the defense, offer you?
None. Nothing.
Are there any negative consequences to your testimony here today?
Objection.
Potentially.
Purely speculative.
In this context, I think it's a reasonable question.
It is. Obviously, he can't predict the future, but he can. I think he can testify as to what apprehensions, if any, he has. So the objection is overruled.
Yes, I felt very scared about what would come of me testifying for the defense. I realize that the district attorney has a lot of power, and that could be bad for me in a lot of ways.
So you obviously knew Zach for quite a long time, and you've been in KCDC. Did you know him to have any nicknames?
No.
Did you ever hear anybody call him Houdini?
No.
Did you ever hear anybody call Zach Superman?
No.
Have you ever been convicted of a crime?
Yes, I have.
You've been convicted 11 times, right?
Yes, I have.
That's all I have.
Cross-examine.
So, Mr. McAtee, I just wanted to be sure I had the details right about what you said on direct. So, if I understood you correctly, should we call it the hole? Is that the easiest way for you to think about it? But it's actually a dorm. It's called HW, right?
Yes.
Okay. And so you were in it for, sounds like, an extended period of time, like several weeks?
Yes.
Okay. And other people were coming and going?
Yes.
All right. And so if I indicated to you that that the jail records indicate that you were in the hole, I'm going to use your phrase, the hole.
I'm going to object if he's basing this question off of jail records. He needs to have some sort of basis for that. He can't just make that assertion.
That's not true. On cross, I'm allowed to describe things, and then he's allowed to adopt.
Well, no, he has to have a factual basis for his inquiry.
Well, he needs to have some sort of basis in the evidence.
No.
No,
Not at all.
factual.
Okay.
May I go on? So if I indicated to you that the jail records indicate that you and this individual, Mr. Washington, were in that security, the hole, on dates of February 2nd, 2022 through February 5th, 2022. So you indicated you were there until sometime in early February, correct? All right. Would you have any reason to dispute my discussion with you that it looks like you guys had in common 3 days from February 2nd, 22 to February 5th, 22?
That may have been so, yes.
Okay. You're not suggesting that it was a longer period of time that you were with Mr. Washington, are you?
No.
Okay.
No.
So this would have been 3 days, about a little, about 15 months ago now? Wait,
Yes.
Is that 13 months? I apologize. My bad math by me. Okay. You indicated that your memory was, if I get this correct, you were on the second floor at the far end.
Yes.
Does that sound right? If I told you that was, and you thought it was cell 22, that's what felt familiar to you?
Yes.
Okay. Farthest down you can be on that second floor?
Yeah. Yes.
Okay. And do you remember are the numbers that are in the 20s the upstairs, or do you remember anything about the numbering system?
I believe so. Most of the 20s,
Okay.
and then on down. Yes.
Okay. And so, if I understood you correctly, this person, Marquand Washington, was also upstairs and was directly across from you. Did I get that right?
I believe so. Yes.
Okay. So these discussions would be, I just want to be sure I have this right. So I'm going to approach you, but I don't want to get any closer. Just tell me how far away the cells are when you two are having a discussion. You're on the same floor.
Mm-hmm.
Is that right?
Yes.
You have to say yes or no. Okay?
Yes.
So if it's a cell directly across from you, am I right about the right distance that you remember these conversations?
No.
Should I go way farther or closer?
Farther.
Okay. So how about now? Am I about right?
A little further.
Okay. So now, see, you got me in the tape here, so I'm not going to go quite that far. How am I now?
A little further.
Okay. Now?
A little further.
All right.
Roughly there.
Okay. Judge, can you just give an estimate for the court about what our distance is right now?
From the front of the witness stand, no, that isn't right. The entire length of the courtroom, from the wall behind me to the wall behind you, is 53 feet. From the front of the witness stand to the bar, to the bar railing, is 19 feet.
So if I suggested to the court it's maybe another 8 feet from there, does that look around about fair? That I'm about 8 feet from the bar?
Yep.
Okay.
It's probably right.
So 19 plus 8 would be, if my math is correct, 27. So
You get an A.
What? Rough estimate of
Get
about
an A.
So Mr. McEntee, this is about right.
Yes.
Okay. And during the time period you were with Marquand Washington, were there other inmates in the hole?
Yes.
Okay. So what about on the second floor? Were there other inmates on the second floor?
Yes.
And then about how many beds or cells are on that second floor? So you guys were two of how many, based on your memory of this?
Somewhere between 3 other people, maybe.
On the top floor?
Yes.
Okay. So it's you, Mr. Washington, and maybe 3 more on that top level?
Yes.
Okay. And so far you're feeling like your memory is Washington is on that second floor, and is he the closest of those 5 to you in proximity?
No.
Okay. So he's across from you, but there'd be people closer away because there'd be cells on both sides of you?
Yes.
Okay. But he's much closer than anybody who would be downstairs, I assume.
Yes, roughly. I mean, someone downstairs in the downstairs corner would be almost just as close.
Okay. What about the far corner? So in other words, the whole course of the dorm across from you, and on the bottom side. Would that be the farthest away from you of the cells?
Yes.
Okay. And you don't know what any of those cells down on the down part are numbered, do you?
1 through 10.
1 through 10? And do you remember, maybe you do, maybe you don't, are the numbers in terms of them, is 1 the ones that would be closest to you? So order,
Yes,
and then
they would be closest to me, below me.
10 would be the farthest?
Yes.
Okay. If there are 10, not holding you to that, but
yes.
Okay. So from that location, and this is where you and Washington are having any conversations you're having about jumping cases, right? You're not having those any other place other than this particular part of the facility.
Well, occasionally when he comes out for rec at night, they have a 1-hour rec where they go in and shower. We have had conversations then too while he was out in the day room.
Okay.
And what he needed to.
And that would actually be a rule violation, right? He's not, when you're out in the day room, you're not supposed to be having contact with any other inmates, correct?
No, that's not correct.
Oh, you're allowed when you have that hour to wander around and talk to people in the cells?
Yes.
Oh, okay. And that was a rule back in 2020? I'm sorry, apologize. In 2022?
I can't say that it was a rule, but
it was
permitted. The guards allowed it.
Okay. So you and Mr. Washington were never cellmates?
No.
Okay. So, but you talked over this stuff, and it sounded like you bonded on just sort of discussions about stuff, right?
About our cases.
Okay. So, where do you recall where, for instance, where Mr. Washington grew up or where he's from?
No.
Okay. Do you know what do you know about his family? Whether he has kids, those kind of things?
I don't know any of that.
Oh, okay. So your testimony is that Mr. Washington, not even revealing where he was from or any circumstances about his family, is talking about how you would lie to about other inmates and make a case, correct?
It's about how to save myself.
Okay. And other inmates are present and would hear those conversations?
Yes.
And Mr. Washington appeared to not be in any way concerned about the idea that other inmates would hear that he was giving you this advice or talking about what he himself would do?
No.
Did he tell you about other cases that he had cooperated on? He must have told you some stories about here's what I did on this case.
No, he didn't get into that much detail.
Well, did he tell you about any times he had cooperated against other people?
No.
You have previously expressed fear that a federal inmate who tells on people, who snitches, is in danger. You've expressed that fear before, haven't you?
Absolutely.
Okay. So Mr. Washington would knew the same thing, right? That
there's
he'd
no
be in
way he
danger?
would objection. There's no way that he would know what Mr. Washington would know.
Yeah, it would be, well, it's speculative as to what Mr. Washington would know or not.
Conversed, and I've never communicated to you in any fashion. Is that right?
Not directly, no.
The DA's office has never met with you, called you, emailed you, sent you anything, correct?
Not directly.
So, and while you have been a federal inmate, back in August of 2021, I'm speaking specifically about August 4th, 2021, you caused fraudulent legal mail to be delivered to you in our jail, didn't you?
I did not.
So, did you have an occasion where you had a legal mail sent to you? Your name is Nicholas McAtee, correct?
Yes, it is.
And the sender was a law firm in Sheboygan called Hawley, Kaufman, and Kautzer. Did you have a
I'm going to
legal...
object. I think he's misstating that there's two cases, and I think you're talking about the wrong one.
I'm talking about August 4th, 2021. And I'm literally reading from a document about August 4th, 2021. Did you cause to have sent to you in the mail a legal envelope where the sender was supposedly the law firm of Hawley, Kaufman, and Kautzer in Sheboygan, Wisconsin?
I did not cause it, no.
Were you the person responsible for devising the scheme where that legal envelope was sent to you in the jail?
I was not, no.
Well, when confronted with this particular piece of fraudulent legal mail by a Deputy Nicla, N-I-C-L-A, on August 6th, so a couple of days later, when they asked you, were you bringing narcotics into the detention facility, did you smile and shake the deputy's hand and say you've been waiting for this day to come?
Yes.
Okay? And then did you go on to say that you had been having narcotics sent to you in custody in the jail for approximately 10 months?
Someone else was sending me the narcotics, yes.
Well, obviously you can't send narcotics to yourself when you're in the jail.
Yes.
So I'm sorry, I didn't mean to get you caught up on that. You were arranging to have those narcotics sent to you in the jail, and that had been going on for 10 months, correct?
Yes, I was receiving them, yes.
Okay? And when you were asked how you received these packages, you said they came every 2 weeks, and you would receive a package from your, and then you indicated lawyer, and they would have narcotics inside.
Yes.
Okay, and you had been previously represented by this Sheboygan law firm that was on this envelope, but they no longer represented you, isn't that right?
Yes.
And so there was literally a lawyer's name on it that I'm not going to say out loud, who in terms of this document was essentially being represented as the person who was mailing you an item that was illegal drugs. Isn't that right?
Yes.
Well, who were you having do this? Who is this individual?
Okay, I'm going to object at this point. You did say there was a limit to this inquiry, because normally the inquiry is just number of convictions, and so he's asked some questions that the court allowed him to.
It's allowed under 90608. But there's been a variety of pieces of evidence along this line, but I do think that you originally asked him if he had orchestrated this scheme, and the witness answered no. So, I'm not suggesting there haven't been other statements that have been made. But as a lead up to this question, I think he's actually denied that. Maybe I'm wrong.
Yeah, well, I'm going to ask him about the person who is on the other end of this, so that because I don't want to be left with his answer based on my cross-examination about his involvement in this.
So he's already made some admissions about what he said to the deputy, and what the state wants to do now is to basically read through the entire criminal complaint and then do it again with the other case. So, I mean, there's a limit to how much probative value there is here, Judge.
I'd like to inquire about all the areas where I believe he's dishonest in this incident, and I'd like to do that on the 2 incidences that I previewed for the court. And I understand that counsel finds this objectionable, but at this point, I've done nothing that's in violation of the statute, and I'd like to conclude by talking about other ways that I believe he's dishonest in this particular case.
I will tell you, I don't want you to go through each specification of each complaint. You can hit the high points.
Yeah.
And you should be able to do that within 2 to 3 minutes.
Well, who is Joshua Houts, who was sending you these items?
That's the person who was creating the packages and putting the drugs in there and sending them to me.
What's your connection to him? How do you know him such that he would send you drugs?
He's a person that I met in prison.
And why would he randomly send you drugs unless you were indicating that this should occur?
Objection. How could he possibly answer that speculative question?
Here's what the problem is. The specific rule that we're working under requires you to take his answer.
I am.
Well, you're not really, because you're challenging him on his former answers. And we're getting into the mini trial, which is the reason that the rule limits the inquiry to just what is contained in the statute. So asking him about specific instances of conduct is permitted, but you're concluded when he answers. You're not going to be allowed to offer contradictory evidence.
But can I ask questions that probes his answers? I understand I can't talk about contradictory evidence.
That's exactly what the rule is designed to avoid.
Well, you know what? It's another one where you're both kind of right. So I'll resolve it by saying you can ask 2 or 3 more minutes of questions, hitting the high points.
You said that a minute and a half ago, just for the record.
So you want me to cut it to
a minute and a half?
Yeah.
A minute and a half, maybe less.
After having been confronted in August regarding the item that I spoke about, did you again? Were you again involved in drugs coming into our jail in December of 2021 by use of legal mail again?
As a party to a crime, I was, yes.
Okay. And did you go to the computer in the area where inmates can do legal work and put together some legal documents and a legal envelope that was created so that it could be sent back to the jail for a local Kenosha attorney to be the individual who sent the drugs?
Yes, I did.
Okay. And so you created what you knew was not a truthful piece of mail, right?
Yes.
And there was an actual lawyer's name on it, correct?
Yes.
And the idea was to utilize that document, that legal document, to bring additional drugs into the jail?
Yes.
Okay. And did you recruit a individual who was a cellmate of yours to be a part of that?
Yes.
And and so were you detected in doing that after the other incident had already occurred?
Yes.
For the records, that was 3 minutes.
Let's wrap it up. And that's directed to all 5 of you. You haven't said a word, nor have. Wrap it up.
Wrap up cross-examination total? Is that what you mean?
No, I mean let's move along.
Okay. Yeah, I'm finished with the complaints. But
bless you.
Have I been lengthy? Okay, I can continue.
No more so than usual.
Thank you. I have nothing else of the witness. Thank you, Your Honor.
Thank you. The incidents that Mr. Gravely just asked you about, what was the drug that was being brought in?
It was Suboxone.
Is that a drug that's used to treat people that are withdrawing from heroin?
Objection, Judge. That appears to be irrelevant. What drug was being brought in the jail?
I don't know why he would want that not to be relevant, but okay.
Please.
Okay.
It's the objection is sustained.
Why did you do that?
Because I'm a drug addict.
So this was feeding your addiction?
Yes, it was. Prior to being locked up, I was addicted to heroin, and so Suboxone assisted me in not going through withdrawals, and I had been on it since I was incarcerated.
Those two cases that were referenced, those were both from, one was from August of 21 and the other one was from February of 22?
Yes.
I'm going to guess from the dates that the one from February was directly tied to why you were put into seg?
Objection, Judge. This all is leading.
Why were you put into segregation in January of 22?
Because I was having drugs sent into the institution.
Okay. So, we covered before about your choice between testifying for the prosecution and testifying for the defense. What would have been required of you if you had testified to your understanding, if you had chosen to testify for the prosecution?
Judge, I didn't ask any questions along this line. It's irrelevant.
I'm going to sustain the objection.
So why did you choose to testify for the defense?
Same objection.
It's a different question.
I didn't ask the
different
question.
As I've said before during the trial, I do not adhere strictly to that rule. Some judges do, I don't. He can ask about it, but it should be a brief examination.
Okay. Why did you choose to testify for the defense?
Because I felt like it was the right thing to do, to bring the truth out and not do something just to try to gain some freedom.
So after you first learned that both parties wanted you to testify, did you talk to your family about it? Don't tell me what they said, but did you talk to your family about it?
Same objection, Judge.
I don't see where it pertains to the subject of the reason for which I permitted the witness to talk about the whole general subject.
All right. Is everything you testify here true to the best of your knowledge?
Objection, Judge, to ask him to affirm.
It's not a permissible question.
Okay. That's all I have.
Any questions?
No.
You missed a step down, sir. Did I hear that was the last witness for today?
I believe that's accurate, Judge.
Yes, Judge.
Okay. Anything for the state?
What?
Anything for the state? I know it's not your case right now, but if you told me you have someone who came here from
a witness during their case? Is that what you're asking?
Yeah, if you had brought a police officer in from
Talk about it.
Arizona.
Talk about a nightmare for the jury.
You know what? Everything else happened this trial, Judge.
Yeah.
Why not?
Yeah, no, Judge, we don't have anything now.
All right. So we're done for the third week of the 2-week trial, and you're just wonderful. You really are. I'm not just saying that. I hope you have a wonderful weekend, and the end is in sight. And don't wag your head or you'll come up here. Please don't talk about the case, read, watch, or listen to any account of the trial. And there have been some incidents today in particular that have had aspects that were drawing a lot of laughs. Of course, I don't need to remind you the awesome issues that you have to determine in this case, and bless you so much for your service to our country and to us, all of each and every one of us as citizens, and have a wonderful weekend. Please don't read, watch, or listen to any account of the trial, nor discuss it with anyone. Somehow I was lassoed into doing a juvenile case, even though I'm not assigned to those, but I'm not assigned to criminals cases either. But I have to do it by law on Monday morning, and it shouldn't take more than 10 or so minutes. So I'm going to ask you to come in at 9:15. And I hope to start promptly at that time. Thank you.